letter that was sent to try and stop the vote.
To try and stop it, yes. Which is admitted, but the minister says nothing about those. But the point here that is made is simply this: these are not the irregularities were brought to the attention of Parliament. It is not as if Parliament was unaware of the irregularities of the committee were brought to its attention. So it approached this task with its eyes open about the problems. So it therefore accepts it. I know that the Speaker of Parliament responded to the DA and said that her advice is that there were no irregularities. That's all fine. But the point here is that if there were irregularities, these were brought to the attention of the Speaker prior to the vote. And so when they voted, their vote was to endorse those irregularities, which is not allowed by the Constitution. Then the second allegation that is made is this, and I think it was debated with Mr. Bishop, which is, however, this conclusion and the insertion in the impugned report, that's the insertion of the word accept, was done post the sitting of the Finance Committee and was not in fact deliberated upon and concluded by the Finance Committee, despite Sinawa Tambo, who is from the EFF, having proposed at the beginning of and halfway through the sitting. The fiscal treasurer should in turn inform the report it was sent, not the other way around. Now look at what the answer McDavid says of Parliament in the next column. It is correct that the insertion was made post the sitting of the committee. I refer to what I've stated and maintain that it reflects an accurate account and statement of what occurred at the meeting. The remaining allegations are denied. Now that allegation is very important because she never identifies where the item that is being voted on, except on amend, is ever presented to the committee during the deliberation to vote on. Never identifies that.
It's common cause, it was not there.
It was not there. But what is concerning is the bold denial by the Speaker, who is herself the repository of public power. When she admits that the insertion came afterwards. And then there is a third, and again, this is not a technical fight. It's a fundamental element of Section 8.4 based on the rule of law. They have been given a power, and the Parliament has decided this is how the power is to be exercised. But they themselves, as lawmakers, are just deciding to ignore it. And then,
Mr. Ngcukaitobi, in that regard, it's also common cause that on the same day of the report, the 1st of April, both the EFF and the DA, their representatives from the committee, email the secretary of the committee and say that's not what was agreed in the committee.
indeed.
And this report does not accurately reflect the situation.
Yes, indeed.
And the following day, in spite of that, and in spite of then letters to the Speaker, both by the DA and the EFF, to say don't go ahead with the vote.
Yes.
It's rushed through and the vote's held.
Yes, they ran through. They thought, we've got this gap now because Action SA is with us. Let's put it through.
Arguably, there would be a basis in which to say that an issue could be discussed by a committee, and the report could be a correct reflection of that report after the fact could then be sent to Parliament. In certain circumstances, fact dependent, that might be acceptable. But in this case, the facts show completely the opposite.
Yes, the facts show that the report was a distortion of what had happened. And that discussion was brought to the attention of the Speaker nevertheless ignored it.
What is to be made of the word approved in the minute?
Whatever that word means, even if it means accept, it is still undermined by the condition, which is also included in the report. Because the section says clear statement, and once you put the condition, it takes away the clarity. So it's the main argument, by the way, by the Speaker, is to say sometimes they use approve, sometimes they use adopt. But they always shy away from accept, which is the language in Section 8.4, because they know that accept is not conditional, even in contract. If you say I accept, but that's not an acceptance. So the third irregularity is then identified in the following section, which again is, objections being raised. And when you look at the answer in affidavit, that's not being addressed directly. And then the fourth one is a fifth one, okay. A sixth one, again, no answers. A seventh irregularity, an eighth irregularity. And what you say is the content thereof is denied, the content thereof is denied. The ninth irregularity, and the 10th irregularity. So we've taken the time to go through this quite carefully, and we've come up with 10 irregularities. So I'm afraid what you have, what the court has, is that it has a report that is so fundamentally undermined by the irregular way in which Parliament conducted itself, which is in conflict with Section 8.4, and therefore cannot be given effect. What that really leaves is, well, can you do the separation? We've showed in our heads of argument that you can't come and rely on a different section after the event. If the minister's case was always, I'm increasing VAT, I don't care about the budget, and I don't care about the fiscal framework. That was never his case. That case came in the answering affidavit. So, therefore, he was always trying to increase VAT as part and parcel of the budget and the fiscal framework. So he's bound by that inaction. Then, well, what is the court supposed to do? Well, we submit that it's inevitable that relief must be given to the EFF and the DA. The question is whether interim relief on the fiscal framework or final relief. We've asked for interim relief. Mr. Bishop, as I understand him, says that interim relief might not be appropriate because it would sterilize parliamentary processes until Part B is ready. It's unclear to us why it would, because if the current process is interdicted, it's clear that they may not proceed with it. But that doesn't mean they may not start a new lawful process.
Can I just ask paragraphs 3 and 4 of the relief, which suspend the report of the standing committee and then the reports of Parliament after that? Has the vote not sailed in respect of that report? What would the suspension of the report do? Because that has already been, that's gone through the process and voted on. And so what would the suspension of the report of the standing committee do at this stage?
Well, my lady, we do ask in paragraph 4 for the suspension of the National Assembly resolution. What we were worried about is that the court might say that there was nothing wrong with the National Assembly resolutions, and therefore we had to attack all of them. But again, if you only gave us paragraph 4, theoretically, you still have the problem that you've got the poisoned report of the standing committee, which still remains and has not been suspended.
What I think my question goes to, is it not the setting aside that should be granted rather than a suspension? Because a suspension, what does it really do?
Yes, it may not be just an everything. Let me just say this. The relief that should be given is just an equitable under Section 172, and that's what Kodan says. And also says that you are not bound by my formulation of the remedy. What you must give is what is just an equitable.
So if it was final relief, you would be covered.
That would be given. I submit that I do meet the threshold for final relief, but we had asked for interim relief, but the fact is that the facts are so clear and the law is so clear that the court will be entitled to give final relief in its discretion. If the court gives final relief to the DA, then my arguments are only supplementary to the DA. I don't need separate final relief.
If for instance, we give final relief, to the DA, and then paragraph 5, which is the interdict, will still stand. Is that right? Is that what you're saying?
Yes.
So in respect of 3 and 4,
Yes.
we can actually give the final relief in respect of that, but paragraph 5 still stands because that's the interdict pending Part B.
Yes. Indeed, because there is Part B even on the DS formulation of the case. But I still need Part B anyway because I need to finally set aside that increase.
Okay. So Part B in this instance would only be in relation to the VAT increase and not the report, because the reports would have been catered for in the final relief.
If you give the DA final relief, then I don't need any final relief. My arguments will simply support what the DA has said.
Okay.
But it's in that event that you think final relief is inappropriate, that I say my paragraph 3 and 4
Okay.
are appropriate.
Okay.
I have nothing else to add.
Yes.
But there are 4 of us. We should be entitled to cost of 2 counts. The case is sufficiently complex. We are immunized from cost by Biowatch.
Yes, we can start a quarter to 2.
Thank you, Mr. Ngcukaitobi. Can we perhaps break early, now at 1:45, come back at 1:45? We'll make arrangements that you come in, you're allowed to come in at 1:45. All right, quarter gents until 1:45. Thank you. Ms. Silo, you have your 10 minutes first, uninterrupted, and thereafter we'll ask.
I'll try and use my 10 minutes. Okay.
Yes.
I have a structure that I was going to follow, but before I do so, I think it is important that to dispose of one issue that creates confusion in the report. And this is in relation to submissions made by the EFF. The EFF addressed the court on the alleged deception by the Minister of Finance. But most importantly, the EFF suggests that they pleaded that case and it was unanswered in the Minister of Finance's answering affidavit. That is incorrect, and I would just like to give the court the references where this issue is dealt with. I'm not at this juncture going to deal with whether or not what the EFF understands to have happened constitutes deception, but I'll address the first one, whether it is dealt with. Firstly, it is in the Minister's affidavit, starting at paragraph 80, and it will be some paragraphs 80.1 and 80.2. As well as at paragraphs 48 and 50. The sum total of the Minister's response is firstly to deny the word deception on his part, secondly to rely on the actual speech that he made on the 12th of March, which is to be found, and that he states in paragraph 18, the whole speech is reflected there. A comparison of the speech and the allegations by the EFF will demonstrate that there was no deception. What the EFF relies upon is what Mr. Trolley of Action SA supposedly communicated, I think, to the public as to what the minister said. The minister in the affidavit denies that those were his statements. And in fact, he states at paragraph 80.2 that he doesn't assume responsibility for any misunderstanding that Mr. Trolley may have delivered. So I just wanted to address that issue and point it out that it was dealt with definitively. Getting back to my structure, my ladies and my lord, this, at least for part A, is, on proper reflection, a fairly simple case. It revolves around the proper meaning of section 7.4 of the Act, which of course must be read with section 7.1.
You're now referring to the DA's case, not the EFF, right?
No, I apologize. My correction to the EFF is done. I am now making my submissions.
Okay.
So I say the entire case, whether brought by the DA or the EFF, revolves around the interpretation of those two pieces, those two sections. We do make the point that the EFF, in its papers and notice of motion, does not challenge the decision of the minister per se. And the basis for that is, as pleaded and is argued in the heads of argument, is that their understanding is that decision is intricately linked to the parliamentary process arising from the portfolio committee. We submit that the EFF is wrong. The legal opinion that the DA references in their founding papers, that they indicate they received, having been labored under the same misconception, is the correct legal position. Those are two distinct processes with two distinct outcomes. Hence I say, today is all about the proper interpretation of 7.4 and 7.1. I will address the question of the claim of unconstitutionality of section 7.4, only insofar as the DA relies on it to demonstrate that it's got prospect of success in Part B. And I will demonstrate that it doesn't actually have prospect of success, because the unconstitutionality they argue for is non-existent. I'll thirdly then deal with the essence of the applicant's case, both of them, but more the DA's case when stripped of all the frills. And lastly, I will address the question whether or not, against the background of my submissions, it can be said that the DA has made out a case for the relief it seeks in Part A, whether one calls it a suspension or an interdict, because the grounds for both are the same. Looking at Section 7.1 and 7.4, the DA departs from the premise that the minister, acting in terms of Section 7.4, imposed a tax. And that is incorrect. The imposition of that tax, which is a value-added tax, is in terms of Section 7.1, such that in the absence of 7.1, there is nothing the minister can do or ought to do in terms of 7.4, because he requires the VAT to be in place, having been imposed by the legislature, before he can deal with the rate of that tax. We know that the DA contends that the exercise of this power is to the minister has the effect of usurping the authority of Parliament and constitutes an impermissible imposition of tax. It is precisely that position that I submit the DA makes, because it conflates what happens in Section 7.1 and what happens in Section 7.4. That imposition of a tax is done long before 7.4 is called into use. It is appropriate at this juncture to consider the entire budget process in its proper context. And I submit that that process starts at Section 27 of the PFMA. Section 27.1 obligates the Minister of Finance to table an annual budget for the financial year in the National Assembly before the start of that financial year. So it's got a period when it must happen. Secondly, the annual budget must be in accordance with a specified formula. It's not recorded for our purposes currently, and must contain at least proposals for financing any anticipated deficit for that financial year. That's in terms of Section 3, sub G. So the budget will deal with all aspects, revenues, expenditures, and everything. Should there be a deficit identified in that budget must indicate proposals to finance specifically that deficit. Section 7 of the Money Bills Act tells us that in tabling that annual budget, and that is Section 7 of that Act, the minister must present a proposed fiscal framework and tax and other revenue proposals. Those revenue proposals in Section 7 of the Money Bills Act are the very same proposals for financing the anticipated deficit contemplated in Section 27, 3, sub G of the PFMA. So, working on either act, it is unavoidable that the Minister of Finance, to comply with the Act 7, where there is a deficit, firstly, he must indicate all sources of revenue, and ways that there is a deficit, he must put forward proposals to address that deficit. As we know then, in this budget 2025-26, in response to the requirement contemplated in Section 27, or imposed by Section 27, 3G, the Minister proposed a VAT rate hike of 0.5% for the financial year 2025-26, with a further 5.5% for the next financial year, cumulatively 1%.
I think the 10 minutes is up.
Thank you.
Okay, you can continue.
We submit that in so doing, the minister at least did the basic, the first, which was to comply with the provisions of both the PFMA and the Money Bills Act.
Can I just ask a question?
Yes.
Since this is the entire scheme, it's a whole scheme starting with Section 27 submission.
Yes.
What happens if at the end of it, the Parliament votes down or doesn't adopt the fiscal framework, and all of it everything that's in there falls away because it's not adopted. So what happens? Can the minister continue with the announcement made in respect of the alteration of the VAT rate?
My response to that question is, Helen will recall that the minister must prepare a fiscal framework, and in terms of the law, once presented to Parliament, Parliament must then direct that fiscal framework to the appropriate committees, including the Finance Committee,
yes,
for comment and deliberation. In terms of Section 4...
In terms of Section 8 of the money for acceptance or amendment.
Indian money.
Yeah.
So in terms of Section 7 of the Money Bills Act, if I can find it...
so what if it's amended? Maybe my question should be rephrased. What if it is amended and amend the VAT rate itself? What happens there?
What ought to happen, on my understanding, is if we go to Section 8, I've gone offline a bit, I apologize for that. If we go to Section 8, and that's the section dealing with the adoption of the fiscal framework.
Yes.
Subsection 6 of that section informs that if the report includes amendments to the fiscal framework or revenue proposal, then the amendments to the revenue proposals must comply with Section 11.3 of this Act. The minister must be given at least 2 days to respond to the report and any proposed amendments prior to the submission of the respective reports to the Houses. And lastly, the respective reports of the committees on finance must include the responses to the minister. Now, if we understand that is the framework,
yes,
it would suggest that the Finance Committee would debate the fiscal framework. It would accept or amend. It's the effect of any amendment. Those amendments must be put before the Minister of Finance for his consideration and response. His response then constitutes part of the fiscal framework, which in terms of Section 8 sub 6, both will serve before the National Assembly.
Yes. Now, what happens if there's a flaw in the sense that the process that you're articulating did not take place as it's supposed to in terms of Section 8? What happens to the announcement, the submission by the minister?
That announcement and its effect sustain until Parliament has voted on the Act to amend the Act to increase the VAT to 15.5%. And it is because of the wording of the Act that provides that amendment or that change sustains and subject to engagement by Parliament of that. And that is the reading of Section 7.4 itself. It subjects that increase to confirmation or rejection, as the case may be, by Parliament. So,
sorry to interrupt you, but at this stage, my understanding is that we're dealing with a fiscal framework. So Parliament must, at this point in time, if the minister announces a VAT rate increase in the fiscal framework, Parliament must then debate it after it has gone to the various committees.
Yes.
And if Parliament decides, well, we don't need a 0.5, we need a 0.4, what happened then?
Then the VAT will be increased by 0.4 because the eventual decision is that of the National Assembly.
But it doesn't, in terms of the Act, is that, in terms of the Constitution, we put it differently, it's only the minister that can introduce a money bill.
Okay.
And the money bill has not been introduced yet of 0.4. When is he going to do that?
It's a 0.5% money bill.
Yes.
Money bill. And the Parliament, in its legislative processes, is entitled to consider that proposal in the money bill, adopt or amend.
Can I just come before that, if you don't mind? Because I'm just wondering, to follow up with what my brother is asking, at this stage, we're still going through the process, the Section 8 process.
Yes.
And are you saying that if Parliament says the report, the committees, and then Parliament endorses it, that we don't want 0.45, want 0.4? Are you saying based on that amendment at that stage, then the announcement by the minister will be trumped by that amendment
Indeed, so, my lady.
without legislation in 12 months' time?
No, the legislation is no. Let me correct myself. What will trump is the passing of a legislation that imposes 0.4.
But that's too early. So if the amendment by the National Assembly is 0.4, then the 0.5 cannot proceed.
It
Because the fiscal framework has now been, there's an agreement on the part of it's resolved, the National Assembly, that a 0.4 VAT increase must be effected. Therefore, the fiscal framework, there's an amendment that has been resolved.
Can I take a step back, my lady? The minister suggests in the fiscal framework 0.5. The portfolio committee considers the fiscal framework. It makes its own recommendations, which are put before the Minister of Finance, who considers them, and that whole lot serves before the National Assembly. So when the National Assembly debates, firstly, the notion of VAT increase and the rate, it has the benefit of all views, and it's open to Parliament to decide.
At that stage, regardless of 7.4 announcement, regardless of what was said by the minister.
Of what was said. However, because of the nature of Section 7.4, which has technically amended the rate in 7.1, to correct that amendment, then Parliament must pass that money bill.
But that's down the line.
That is down the line.
But what happens from the 1st of May if
Then
Parliament
then
had...
the minister's determination must subsist.
That's what I'm saying. I'm trying to ask. Despite the 0.4 amendment.
Because of the effect that decision has, it has already amended the Act.
How can that be, Ms. Sero?
And that's the point I'm coming to, my lady. Whether or not that is possible. We submit, yes, it is. And that is the case I seek to make to this court. So if, for the moment, the court were to accept that the effect of that announcement is to amend that Act, then that Act has to be amended. If eventually the decision is 0.4, and to amend that Act, Parliament will have to pass the money bill.
But what is the purpose of the fiscal, of Section 8.4 of the Monies Bill Act?
The purpose is to give, and I think it's stated in the Act, the opportunity to engage with the views, the suggestion, the basis upon which the proposal, in this example, to increase the VAT by 0.5.
The purpose is to accept or amend the fiscal framework.
No, my lady, it is not for the portfolio committee to accept or reject. That is for Parliament to do.
But there must be a clear statement, though, by
Well,
them.
that is a statement. That is a parliamentary requirement.
So that it goes to the committee, and they must then make a determination as to whether they accept or amend it, and then it goes to the National Assembly. The National Assembly then decides whether it resolves to accept or amend. As I understand you, if they resolve to amend, that matters not, because the minister is going to go ahead anyway. Because 7.4 permits the minister to do so.
If who resolves, my lady, the portfolio committee?
No, Parliament.
Yes, if, let's say, the portfolio committee suggested to amend, and Parliament adopted the minister's proposal, it will be 0.5. Because they eventually decided.
No. The other way around.
No, I'm starting with that scenario. The second scenario is if the portfolio committee rejects 0.5 and recommends 0.4, and Parliament adopts 0.4. That's the scenario where the issue is paid.
Yes.
The question is, has that affected the 0.5 adjustment made by the minister in terms of Section 4? And we submit not.
Then what is the role of Parliament?
The Parliament has to engage with that money bill. That reflects that.
Within 12 months.
Within 12 months.
So what if we have a reckless Minister of Finance who decides it's going to be a 25% VAT hike?
Then it won't be a reckless minister, it will be a reckless National Assembly.
No, because on your argument, the minister can go ahead regardless of what Parliament says.
The DA made a submission that that bill can be passed, I think on their estimation it was June, July. The process is you can only amend an act with an act.
But
No.
what I'm saying is,
Except for, that's a peculiarity of 7.4, which I want to get to now.
but how can we accord such power to a minister in circumstances where the raising of revenue is ultimately for Parliament?
May I park that question? I'll get to it because I want to, it stems from the notion of unconstitutionality that is pleaded by the DA. And perhaps if I work through my argument, we will get to that point where I address her ladyship directly, that answer. And I will get to that answer because this is what it's all about. On the question of unconstitutionality, the first case, and it's not in our hands, we invoke this in response to the DA's head of argument, where they rely on Smith, Casino Association, and Ditaba. In order, and our submission is that those are distinguishable. In order to understand why we say they are distinguishable, we must go back and start with the certification case. In 1996, 744, and we know that's a constitutional court case. That case engaged the principle of separation of powers. And it highlighted that our constitutional dispensation is such that we do not recognize absolute separation. At paragraph 109 of that document, the court highlighted that the principle of separation of powers recognizes the functional independence of branches of government. On the one hand, the principles of checks and balances focuses on the desirability of ensuring that the constitutional order as a totality prevents the branches from usurping each other's power. In this sense, it anticipates the necessary or unavoidable intrusion of one branch over the terrain of the other. No constitutional scheme can reflect a complete separation of power. The scheme is always one of partial separation. And that's our starting point. Accepting
But
that.
are you suggesting that raising taxes, in the true sense of the word, is that now dual power, part of the legislature and part of the executive?
Raising taxes, no. The section 77, I think, of the Constitution tells us only a legislative body may raise tax. And we say that has already happened in section 7.1. What we are dealing with here is the rate of that tax determined by the legislature.
But it's being raised to 15.5.
It is the rate that is being
Raised.
May I say, perhaps sometimes it does get to be a bit confusing when we speak of raising tax. The appropriate, I think, phrase to use is imposing tax. I accept, I have no difficulty that only the legislature can impose tax. So that's section 77 tells us so.
Now, what did the minister do on the 12th of March?
What the minister did was to adjust the rate of the imposed tax in terms of section 7.4. And that is the distinction that cannot be overlooked.
Raising revenue. Wasn't that raising revenue?
It was. Well, the effect of it would be to raise revenue for the National Revenue Fund.
Yes. So isn't that a legislative power?
And that is why at the time of the budget, he filed simultaneously with the revenue bill, the money bill adjusting, in order to amend section 7.1, where it stipulates a tax of 15%.
But what if you do get a minister that don't do it?
Madam?
Sorry, what if we do get a minister that don't do it, file it simultaneously?
It has to be done. That is imposed by section 27 of the PFFA. Together, I think, with section 7, it stipulates what must be submitted at the point that the minister submits, announces his budget in the National Assembly. If he doesn't, it's non-compliance. And Parliament is entitled not to consider that proposed budget. So it would be a clear case of non-compliance with applicable legislation. And, if the
But the announcement will still remain. His announcement will still remain
Well, I
in
doubt
terms of
his-
Section 7.4.
His announcement will remain because I doubt whether his budget will serve before Parliament for him to present the budget to Parliament when he makes those announcements in Parliament. So if his budget is non-compliant, that budget won't serve before Parliament. And it is only at that point where he presents the budget that he's got the opportunity to make that announcement. So Parliament ought to have satisfied itself. I don't have the reference now, but I would expect Parliament to satisfy itself that the budget that the minister intends to present on the 12th of March is fully compliant with applicable legislation.
Can the amendment by Parliament to 0.4 coexist with the minister's proceeding of the amendment of the announcement in terms of Section 7.4? So if Parliament says we want 0.4, but legislation has not yet been enacted, can that coexist with the current 7.4?
If Parliament were to be of that view, Parliament would have to take steps to stop the efficacy of the minister's decision. And those steps is promulgating an act.
But Parliament can't do it. It's only the Minister of Finance that can introduce a money bill.
It is already before Parliament.
No, but that's a 0.5.
That's 0.5. And
We're talking here if Parliament decides it's now 0.4. What's happened then?
Parliament may propose to amend it, which would mean that the money bill presented to Parliament for deliberation and adoption is not adopted at 0.5, it's adopted at 0.4. Continuing on the question of constitutional, absolute constitutionalism, I'll only have reference to Musaneke DCJ in Shuttleworth, where he reiterated the point that we must start by recognizing the fact that our constitutionalism does not insist on an absolute separation of powers between the three arms of the state.
Which paragraph, sorry, of Shuttleworth?
I'll ask my junior to find it for me, I apologize.
Okay.
I'll find
Okay.
the actual paragraph.
You can proceed.
In the case that arose from the Western Cape, I don't have the full citation here, and I'll ask my junior to get it for me. The Constitutional Court was dealing with the question of a Section 16A of the Transition Act, which the President had published in a proclamation. The effect was to alter the structuring of the government. And at paragraph 65, the Constitutional Court noted first that no constitutional scheme can reflect a complete separation of powers. But even accepting that, the provision that was challenged at the time was overbroad and trammeled as it empowered the President to amend the Act and its schedules. In simple terms, it granted the President the unfettered power to amend its primary terms in any way he deemed fit. And that's at paragraph 65. And that is the distinguishing feature we submit between Section 7.4 in this case and what was then Section 16A of the Transition Act. In the certification case, Mohammed VP agreed with Charles Carson, who penned the majority, who penned the judgment for the court, and he highlighted specifically that the delegation of lawmaking authority from Parliament to the executive is necessary for expeditious and effective lawmaking. These comments are made in paragraphs 127 and 128, and concluded on the certification judgment, and concluded that Section 16A went too far and effectively constituted an abdication of parliament legislative function at paragraph 144. In this regard, Sachs Jane, agreeing with both Mohammed and Charles, provided a useful guide as to whether in our environment of partial separation, what can be done to ensure that once, I won't call it a quote, once one arm of government exercises a power that under absolute constitutionalism would be unlawful, what must be guarded against. And he gave a list of factors to be considered, which would be helpful in determining the legality or otherwise of that exercise. And in this regard, he listed about 7, pointing out that they are not, the list is not exhaustive. The first was the extent to which the discretion of the delegated authority is structured and guided by the Enabling Act. We submit that 7.4 specifically stipulates that it is subject to Parliament, minister's exercise of his power to adjust the VAT rate is subject to parliamentary adoption. So it will comply with that requirement. The public importance and constitutional significance of the measure. The more it touches on question of broad public importance and controversy, the greater will be the need for scrutiny. In this regard, we say the amendment is introduced by way of a money bill, to be debated, adopted, and amended by Parliament. The third is the shortness of the time period involved. Section 7.4 compels Parliament to engage with the ministers as a quote-unquote amendment. It's not a choice for Parliament. And it must do so within a period of 12 months. So if it passes a money bill for 2 months, within 2 months, that approves 4%, then the VAT rate will be 4%. If it waits until 12 months or 10 months, then the ministerial decision must prevail until Parliament has made that amendment.
But it's my understanding is, and please correct me, is that when the minister made the announcement on the 12th of March,
yes, ma'am,
he indicated that from the 1st of May, it will come into effect. Now, thereafter, the money bill gets introduced, it appears, and also thereafter Parliament gets engaged. Now, if Parliament, during that process before the 1st of May, come to the conclusion that, look at all of this, this is the fiscal framework, we accept in terms of certain of the expenses and how much money the National Treasury can get for us, but we have the view that it must be 0.4%. What's happening from the 1st of May?
Then Parliament must pass an act adjusting that to 0.4%.
But we know that they won't be able to do it before the 1st of May.
I think it was suggested that they could do it by June this year, which would be a month after the 0.5%.
Now, what's happening during that month period?
0.5 applies, madam. I mean,
But can that ever be? If Parliament has decided that we don't agree with the minister, it must be 0.4. So what's happening, sorry to interrupt you, what's happening is that the executive has taken over the power of the legislature. Even whether it's for a month.
what happens in
Can that be tolerated under our constitutional scheme?
Indeed, my Lord, we submit that it can be tolerated, and it must be tolerated. Because Section 7.4 grants the minister, delegates that power for a limited period, and subjects the exercise of that power to parliamentary oversight. And our constitutional court has accepted that that is a proper delegation of authority. The difficulty arises where parliamentary oversight that no longer applies.
But my understanding from what you've said so far is that the imposing of tax remains in the domain of the legislature.
Of taxes.
Yes. Now,
For instance, my lord, I think the EFF suggesting a imposition of a wealth tax and the like. That is purely the preserve of the National Assembly.
yes, but raising VAT, is that also not part of raising revenue?
As raising VAT in terms of adjusting the rate or
Yes.
imposing a...
Well, whether you want to say raising or want to say imposing, let's say imposing.
Imposing VAT is a function of the legislature.
Good. Now here the minister makes an announcement of 0.5. The legislator said, no, we're not agreeing with the minister, it must be 0.4. But his announcement trumps that of the legislator,
And
even if it's for a month.
It is because the act of the minister amends that act.
Okay,
Now,
so
we will get to the point whether or not that is constitutional, and that's the one I'm trying to.
so can I just get that last point? So you concede that it amends 7.1.
The rate in 7.1.
So the announcement as altered, or the alteration of the minister amends 7.1. You
Yes.
concede that.
Insofar as the rate is concerned, I do.
Okay, just to follow up another point there. So if Parliament says, hang on, we are not happy, we want a different rate because this one is unlawful. Let's assume that its reason for not accepting it is a constitutional reason or a reason based on it's unlawful. Now, and the minister goes ahead based on 7.4, can that happen?
Then the Parliament must pass an act to undo, quote unquote, the increase by the minister, because that increase has affected the rate contained in Section 7.1.
Even if it's raised unlawfulness within the month before the legislation is passed? Even if it's raised an issue of constitutionality within that month period?
If Parliament has...
If Parliament has raised that, minister, we think that this rate that you're imposing is unconstitutional or unlawful based on ABC. Now the minister says, well, even if you are legislature, but based on 7.4, I can continue to go ahead.
Because because of 7.4 and its wording, you must pass an act.
So your answer is yes, it must go ahead.
It must?
It must go ahead.
What must go
The
ahead?
7.5 must go ahead, even if there's unlawfulness or unconstitutionality.
7.5.
On this question of my sister.
It's not a question of if there is unconstitutionality, then we must rush to court and come and address that unconstitutionality. In which event then it would be invalid and unlawful.
But that is why the DA and the EFF is here.
And they are here, and we say they are here. It's wrong that they are here because what is happening in 7.4 is not unconstitutional. And that is the argument I seek to persuade you on.
Okay.
It is not unconstitutional. And I will distinguish both Smith and Mohamba to demonstrate that it is not unconstitutional.
So is the oversight role on that scenario of Parliament not curtailed in that situation? Because if Parliament can raise and say, well, as a legislative body that's entrusted with tax imposition, I'm unhappy because this is unconstitutional. But then the statute grants power to the minister to go ahead anyway. Isn't that curtailing the supervision, the power of Parliament in that situation?
To answer that question, may I request my junior to look up something and I'll revert my native video.
Okay.
It was to check precisely that question, the question of whether or not it's open to Parliament to reject the framework, the fiscal framework, or the understanding of the current legislation. It stated that Parliament can only amend that framework. The question then that arises, I think, from her ladyship, is what if they amend to 0.4? What is the status of the decision of the minister? And I submit that it stays at 0.5 until that money bill is promulgated.
Okay.
Now, going back to the factors that SACS J proposed to be considered in the certification judgment, one of those important is to consider the degree to which Parliament continues to exercise its control as a public forum in which issues can be properly debated and decisions democratically made. We note that in their case and in their argument, the DA doesn't spend what we propose as sufficient time on the phrase subject to set out in section 7.4. It is the meaning, import, and impact of that phrase. And if I can give the court the citation, S versus Marwani.
Is it in your heads of argument?
It's not, my lady, that's why. And we've prepared the copies here for the court.
Yes, please, can you hand it up?
They're being distributed.
Thank you.
The first is State versus Marwani 1982. And in particular, I would like to refer the court to page 747H to 748A.
747H.
To 748A. And in that case, the appellate division pointed out that, as the court found it,
Yes.
the word subject to, in that context, refers to the provisions of this constitution in a particular section that was challenged. And the court held that, considered the purpose of those words, and said the purpose of the phrase subject to in such a context is to establish what is dominant and what is subordinate or subsidiary. That to which a provision is subject is dominant in case of conflict over that which it is subjected to. This ratio was recently adopted as well. And the second case I have provided, that's Zanzi versus Council of State. It's a constitutional court judgment.
You don't have a copy of
We
that?
have two judgments,
No.
two cases.
Okay, we have one. Ori Marwane.
There's an error happened with distribution.
Okay.
There should be two, that and one for Zanzi.
No problem.
And in Zanzi, I would specifically like to refer the court to paragraph 27, which considered the ratio from State versus Marwani, and concluded that as to its meaning, he agrees and adopts what Miller J.A. stated in that passage at 747H to 747A. Other courts have also adopted that meaning. And just to point out, Chevron Engineering, I'm not relying on it, 2003, 5, SA 206.
Sorry, where are you now?
Now, I pointed to State versus Marwani, I gave the protocol.
Yes, we
And
there.
then to Zanzi.
Yes.
And I'm just highlighting other cases where that dicta in Marwani has been adopted as correct.
Okay.
And it's really useful in a matter like this to have this in the heads of argument.
My lady, this was necessitated, I do apologize, by the posture assumed by the DA in their heads of argument, in reliance on Mashoba, Casino Association, and Smith. And we realized that we had not dealt with these issues in our heads of argument. And in order to address that aspect of the argument, it became necessary to lay the foundation on why we say that they are distinguishable. And we do apologize for the oversight. We will upload the cases with the leave of the court as soon as we can.
Having read this, what is the point you would trying to make.
The fact that that phrase, subject to, is what assures parliamentary oversight and control. And that is what leads us to the case of, for example, Matroba. Perhaps if we go to Mutraba.
Is there any contention on that? That it is subject to parliamentary oversight at that stage,
Yes.
not at the stage, not in between the announcement becoming effective and the legislation being adopted. So in between, I think that's where the contention lies.
And we do appreciate that, except if that is the case, then Mutraba, Casino Association, and Smith will not assist the court because they did not have parliamentary oversight. The impugned sections were definitive, and once that power is exercised, the legislature and parliament didn't have oversight to reverse what was done in terms thereof.
But what happens to the public in that period?
Confusion in public and
Meaning the democracy that I think my brother spoke of earlier in the morning, that the public that is supposed to be entrusted with this via the legislature, what happens to them in that meantime?
the 0.5% will apply. And as
But isn't it there where the difficulty lies? Because if Parliament still have to reconvene and discuss and debate and vote on it, the Minister's recommendation for a VAT rate increase stands, even at the displeasure of Parliament. So how can we ever, within our current democracy, allow that the executive is dominant in that respect?
I don't think that the executive is dominant. In the certification case that I referred to, the Constitutional Court recognized that it does become, at times, imperative that there be a speedy execution, and that which Parliament does not have by its nature. So therefore, the law must allow for the speedy execution subject to Parliament exercising its oversight over that decision. And that comes from the certification judgment, my lord.
Just on that point, Mr. Bishop says this is not an emergency where you are reacting and you have to implement something speedily as the minister, but it is a process. It culminates from the process of planning the budget and all that. So it is not something that, there is an emergency that we now have to respond to.
Well, I guess the question of definition of emergency. It becomes apparent during the process of during the budget process. From paragraph 20 to paragraph 40 of our answering affidavit, we set out the process, the budgeting process, culminating in consideration by cabinet and approval or disapproval by cabinet, in which event it has to be amended. In that process, the deficit has already been recognized, and the deficit is quantified and must be addressed. So it becomes an emergency in a sense that at the time it is tabled and the deficit has become clear, then that deficit must be met speedily. And the only way, at least for purposes of our argument here, is that in his wisdom, the Minister of Finance found that the adjustment of the VAT rate by 0.5% will address that deficit.
But on that score, what must we make with the argument by Mr. Ngcukaitobi, where he said, if one has regard to what's been discussed in the commissions, I mean, the commissioner says, listen here, if you fund me properly, I will be able to go to certain areas where we can definitely get more taxed from high net worth earning individuals, companies that hasn't paid properly their taxes, etc., etc., etc. So what must we make of that?
Then we are
So it appears what the commissioner says, although he abides with Part A, is that if you fund me properly, I will be able to get the money necessary, so it's not, there's no need for a VAT increase.
Then we are in the realm, my Lord, I submit, of preferable choices. We are in the world now of, is it open, for instance, to the court or anyone to suggest that of various options available to the Minister of Finance, there was always a better option to the one assumed by the Minister of Finance. And that is the case of pharmaceuticals, and that where it is established that it is not open to challenge purely on that basis.
But are you saying this is a regulatory power and not a revenue-raising power that's being exercised by the Minister?
No, I'm not saying it's a regulatory power.
But then I don't understand what the
Perhaps
relevance of
I
pharmaceuticals
don't understand the question if an issue could be stated.
So, my understanding of casino association in those cases is that there's a distinction drawn by the Constitutional Court between regulatory and
Yes.
revenue raising.
Yes.
Regulatory processes and revenue raising processes. If I'm to understand you, this is simply a regulatory process, 7.4. It's not revenue raising.
Well, this would be raising revenue of what, 13 billion.
Yes, that's quite
the
right.
state, yes.
So if it is raising revenue, then how does it fall? How does it then fall squarely within the terrain of the minister and not subject to parliamentary approval?
Because it is not determining whether to raise revenue by imposition of VAT. It raises revenue by increasing the rate of VAT.
So you're saying the increase of the rate of that is the exercise of a regulatory power as opposed to the exercise of a revenue raising, it's not a revenue raising exercise.
In the context of exercise of regulatory power, I think in the context of Shuttleworth, I wouldn't say that because it does not seek to correct any misconduct. It is very clear that it intends to increase the revenue that the state...
So is it not the exercise of a revenue raising power then?
I don't know if it's an exercise of a revenue raising power because the exercise of that power is already in section 7.1, it is done. It is a question of adjusting the rate, and that is the distinction between 7.4, 7.1, rate 7.5.
So let me understand what you're adjusting the rate in your mind is what? What is it? What kind of exercise of what sort of power?
I would think that it's a delegated power
To raise revenue.
to increase the rate of revenue.
So how can that happen when this Constitutional Court has been quite clear that that may not happen?
Because in casino association, the court had an issue that the minister, the act provided for, rates to be paid, and the minister was to determine that rate. And that was the end of the debate. And in that sense, then the minister is the one who determines the rate with no reference to the legislature.
But in this case, the minister has determined the rate subject, hinged to the annual budget, tethered was the word we used earlier, which is prepared by the minister.
Yes?
And it's not subject to parliamentary oversight,
It is.
but only subsequently.
Section
on your
7.4 says as much. It is subject to
But
parliamentary oversight.
As I understand you, only subsequently.
It can only be subsequent because unless it is placed before Parliament, there is nothing for Parliament
So
to
what is the
confer.
purpose of 8.4?
8.4 is to give the Parliament opportunity to go through its processes via portfolio committees to debate that fiscal framework, which incorporates this
And then
adjustment.
what is the effect of the resolution of Parliament?
After
After
it has debated.
after it's gone through the committees and the report's been taken to Parliament, what is the effect of that
And it is to
resolution?
adopt the money bill presented before Parliament.
But that wasn't what occurred in this situation on the 2nd of April. What was the resolution that was taken?
Well, what occurred on the 2nd of April, we pointed out in a document that is a matter that we will leave to Parliament, and we accept that it may have its challenges, and I'm not saying yes it did or it did not. I point out specifically with reference to section 8 sub 6 that the fiscal framework is presented, it goes to portfolio committee, they make their recommendations, the minister comments thereon, and it goes to Parliament for final decision. Now, Parliament may make a decision inconsistent with the recommendations made by the Portfolio Committee. It's open to it.
The notion of no taxation without representation seems to be a sort of vague concept in the mind of the minister. I mean, you seem to put aside parliamentary processes and say, well, you can come back within 12 months and tell me I'm wrong.
I don't put them aside, my lady. I accept that because of the speed required to address the issue, our constitution permits a provision such as Section 7.4 to allow the minister to make the necessary adjustments subject to parliamentary oversight.
I think we've seen in the world the dangers posed by executive creep, with executive orders made not tethered to the constitution always.
But this one is precisely because certification tells us that that separation is not absolute, it is permissible. It has to satisfy certain factors in order for it to be allowed, chief amongst which is to locate within the impugned section whether parliamentary oversight is retained.
So if I could just understand you, Mokhlaba doesn't apply, Casino Association doesn't apply, Shuttleworth is also distinguishable on the minister's argument. All those decisions of the Constitutional Court are distinguishable.
Let me start with Mokhlaba for the moment. The court will recall that in Mokhlaba, the impugned section gave the power to impose that tax or levy, what it was, to the traditional council with the concurrence of the premier. And it ended there. And Mokhlaba did point out that that's a plenary function and only a legislature may do so. So on its own terms, Mokhlaba would never have survived. And I say that Mokhlaba does not have the necessary parliamentary oversight implicit in that impugned section. And that was the basis on which it was held to be unconstitutional.
Do you still have a long argument to present? Because you probably have about 5 minutes if I look at when we started.
I have about 5 minutes.
But I understand that we've engaged you quite a lot.
Thank
so,
you.
Yes.
And when we say the Casino Association also had that problem.
That there's no parliamentary oversight.
That there's no parliamentary oversight. It's the absence of parliamentary oversight within the impugned section itself that will render it ipso facto unconstitutional.
So is there any case that does apply?
To New Africa. New Africa would apply. And I think the exposition set out by Justices Rogers and Polapen is of assistance in this regard, where they listed the sections in various acts that have the same provision. And all of them, what they have in common is that they retain parliamentary oversight.
But was that premise accepted by the majority?
It was not resorted to by the majority, if I understood the judgment correctly, my lady.
So they adopted a different reasoning to that of the minority.
I was saying what is set out by Justices Polapen and Rogers is persuasive and explains this oddity that I am trying to argue, and the basis on which I distinguish Section 7.4 from Mokhlaba, from Casino, and from Smith. If one has regard to those sections listed in the, and this starts at paragraph 173 of the judgment, and involves the Customs Act, the VAT Act, and the like. It's a categorization of the various types of sections that would permit for an act by an executive in circumstances where the parliamentary oversight is maintained. In this regard, they point out that New Africa's argument at the time rested clinically on the approach to the separation of powers, and that the delegation of lawmaking power, which is too absolute for efficient governance in a modern state.
But didn't the majority in paragraph 105 of the New Africa Judgment put paid to that notion as it was developed by Rogers and Colopin J, where it says that in determining whether a charge is a tax, one has to find the dominant purpose of the legislation. And it goes further. The seminal test is whether the primary or dominant purpose of a statute is to raise revenue or to regulate conduct. And what they've decided here in New Africa, it regulated conduct.
In that instance?
Yes.
Yes. And it's because if we look at Shuttleworth, that is where that distinction was drawn.
But what is the importance of that distinction? The importance is that if it raised taxes, it falls in exclusive domain of the legislator.
Did it impose taxes in the contract? Did it impose taxes?
Well, imposed.
Because in Shuttleworth, it was held that it was not imposing a tax.
And here the minister imposed tax by raising.
Section 7.1 imposes the tax. The minister adjusted the rate at which.
But the adjustment is revenue raising. It's not regulatory.
No, it's not regulatory. That much I would see.
So you concede then it's distinguishable from New Africa, which was regulatory. It was responsive to the conduct of diplomats who were abusing the duty-free entitlements that they have.
I do, and hence my reference to the minority judgment and the base and.
So there's not a clear judgment of the Constitutional Court that's on all fours with your argument.
For now, there is in my lady, because all the cases that have come to the Constitutional Court, Matroba, Casino Association, Smith, they all had the flaw in that they did not provide for parliamentary oversight. In Shuttleworth, it was held that it was not an imposition of tax.
What I find interesting from the minister's perspective is that this imposition of a higher tax rate in respect to VAT has national significance and particular significance to the poor. And that's the reason that the EFF has invoked the various provisions in the Bill of Rights. And in those circumstances, it seems somewhat unusual to rely on New Africa, which was really a case responsive to a particular conduct by a small class of people, when in fact this has national significance to almost every person living in the country.
Yes, I would like to place on record that the potential impact this will have on the poor is not lost on the Minister of Finance. If her ladyship recalls.
But then why is the minister so adamant to raise or impose the levy or raise VAT when the commissioner is of the view that there might be other different avenues to fill the gap of the revenue?
There might be other avenues. It's a question of their availability and immediacy to address the deficit.
Did the minister say availability or the extent to which they will dent the deficit, if I were to use that word? Is it a matter of availability, or the minister seeing that as not really being as significant enough to be able to meet the deficit?
No, well, on the basis of what SARS is talking about, it can be said to be significant, because what SARS suggests can potentially be raised is significant. The question is, it requires capacitation of SARS and providing resources. Exactly when that money will begin to flow in to address the deficit is not an issue that is before us.
Okay.
The Minister of Finance has dealt with other options, including raising national debt.
Okay, I think we're gonna have to stop you at 3 o'clock. I know that we've engaged you, and at least, but I think you should wrap at least at 3 o'clock,
okay,
so that we can give Parliament their chance.
On the question of to her ladyship's question about the national impact, there is a potential impact that borrowings would have, and these are factors that the Minister of Finance has considered in making the choice that he did, and these are articulated in the answering affidavit. It cannot be accepted that the raising of borrowings against the 3 billion debt standing is not going to have any impact. The other side of the coin is the impact, unfortunately, on the same class of people if that deficit is not met, because there would not be sufficient funds to meet the social programs that government is responsible for, including health, including school, including paying grants. And that is the way that the minister must undertake. So it is not like the minister is oblivious to the impact of the VAT, the 0.5 adjustment. At the same time, he is not oblivious to the failure to raise revenue in the interim to meet the social programs that the very poor, unfortunately, depend on. Some members of society depend on private medical aid and the like. The poor, unfortunately, rely on the very public hospitals, which the Minister of Finance must make provision for. The question I just need to quickly turn to is whether or not the applicant has made out a case for the suspension, whether it's interim relief or whether it's an interdict or whether it is suspension. We submit based on the way it is pleaded. It amounts to the same. I would, in this regard, refer the court to by the applicant, I mean the DA, because we know that the EFF is not seeking to interdict the minister's decision. These matters are pleaded at paragraphs 116 to 118. The most important being the right of the public not to be taxed without representation. And that is the fact that the introduction of 0.5% at the time of introduction had not been adopted by Parliament. And as we have argued, in the context of the nature of our constitutional scheme, that is permissible as long as Parliament retains oversight and can address that adjustment, whether to adopt it or to reject it, in which event it ceases to apply. The second is the question of prospect of success in the constitutional challenge, and we sought to demonstrate that based on the cases pleaded and the cases involved in support thereof, Mutlaba and the like, that challenge is unlikely to succeed.
The debates that the bench has had with you and the problems highlighted, the debates that the bench has had with you and the problems highlighted, don't they really illustrate that perhaps there are prospects of success that need to be dealt with at the later stage in Part B? Doesn't that at least show that?
I wouldn't, unfortunately, say so. I would say it may create a debatable case in Part B. Not that Part B will necessarily succeed. And we have...
But our function is not to determine whether it's going to succeed. Our function is just to determine whether it's a prospect of success.
Prospect of success in the relief that it seeks in Part B.
Yes.
Yes. So, and that's what I call succeeding. So, if there are prospects of success that the relief they seek in Part B would potentially succeed, then I do accept that that's what the court takes into consideration.
Yeah, in light of the potential incongruence between the parliamentary process and 7.4, in light of the fact that you say there is no particular case that meets your case necessarily, or your defense necessarily, isn't that an illustration that there has to be some canvassing of this issue in Part B?
There's only one case, except it's not the constitutional court, that I would say is more or less on fours with our case, and that's the case of this court in Pioneer Foods. I just mentioned it. I'm trying to find the correct citation. It's across the paper. There are two of them. The first was also for interim relief, and the second was Part B. It's Pioneer Foods versus Minister of Finance, 2019 1 SA 273, Western Cape, and that was a judgment of September 2017. The second is second is also Pioneer Foods versus Minister of Finance, and the citation there is 2018 for all SA, page 428, and once again it's a judgment of this court. Those judgments were confronted with similar issues.
On prospects of success.
No, just generally on what the court was dealing with, the exercise of the power by the minister within a context of an abuse action. And structured more, in large part, similar to what we have here, where the first was an interim interdict and the second was dealing with the constitutionality of the section in Part B. So I'm saying that if we accept the constitutional structure that we have and the notion of partial separation and the fact that it is permissible for the legislature to delegate a power, such as happened in this case, to the executive, subject to maintaining parliamentary control, then that would not be unconstitutional. The Congress, of course, applies. If the court were to find that it will always be unconstitutional, then I would be paid to that argument. Lastly, I would just like to point out the principles set out in Outer regarding the restraining the exercise of the executive power, which, for now, falls within the exclusive terrain of the executive, and invite the court, as the constitutional court did in Outer, to carefully assess how and to what extent the relief sought will disrupt the executive. The disruption in this subject would be, firstly, the entire fiscal framework would have to be returned to the Minister of Finance to consider another means of addressing the deficit that exists in the budget. The means that eventually he could determine are applicable, and I'm not saying necessarily they are, could very well have this is an impact on the country than the introduction of the 0.5%. Secondly, it would significantly delay the parliamentary budget adoption process, which means at the start of the 1st of April, technically, the government would be without an approved budget and would not be able to fund its obligations.
But Ms. Saylor, Parliament can rectify all of that. If the money bill has been introduced, Parliament can consider it. Because if Parliament consider there must be a 0.5 VAT rate imposed over and above the 15, which means 15.5, that's the end of the story. That's the end of the matter.
And our submission is that the bill is before Parliament.
Yes, but if, and in the interim, what's going to happen in the interim?
Or within the context of his lordship suggesting that it's not necessary for the power in 7.4, because it can be done through the introduction of a money bill. Unless I misunderstood it.
What I'm saying is in the power of Parliament to decide and to impose taxes. If Parliament decides by majority votes that the 15.5 VAT increased from the 1st of May and then thereafter another 0.5% to make it 16% in 2026. If Parliament decided, that's the end of the matter.
That's correct.
But Parliament must decide it. It's not up for the minister to do that.
We are suggesting that the minister is empowered to do so in the interim while Parliament runs it through its process to confirm and compare. Actually, the section compels Parliament to do so, to confirm or reject and overturn that adjustment. And that is in law permissible, based on the cases that we have cited, and that it is not unconstitutional to do so.
Okay, thank you. On the issue of costs, as well as there's one point besides costs. Whilst you're thinking about costs as well, paragraph 5 of the EFF's relief is broad enough, I think, to include all respondents, because it wants to interdict the giving effect, including the introduction of the 0.5 percentage points, pending finalization of Part B. doesn't that implicate the powers of the minister?
Well, our understanding of 5 was the EFF sought to interdict the giving effect of the impugned report in the fiscal framework, and that is all they seek.
Or taking any steps in relation thereto?
And taking any steps in relation to that fiscal framework.
Okay.
And the point that we make is that even if it succeeds in that regard, the power exercised by the minister in terms of 7.4 remains unaffected.
Okay. And the costs?
On the question of cost, my lady, we ask for costs because it is clear, it must be clear from these papers that technically what the DA sought to do is to achieve through judicial intervention what it could not politically. We have pleaded at paragraph 30 of our answering affidavit. It's part of a bigger subject, which is the budget process. That demonstrates continuous engagement with all cabinet members, and these are members of the GNU, that takes place in cabinet. That is not denied by the DA, so it must be accepted that that process was fully followed.
But what of their reference to the 2014 decision of Rogers J in this court, in which it was said that you must look at the character of the litigation?
I understand that, except that my point would be the character of the litigation cannot detract from an attempt by a litigant to use court processes to draw the courts into arenas that are political in nature. If the DA accepts that there was full engagement with the political parties in the GNU that eventually adopted through cabinet the budget, it cannot seek court's help to extricate itself from there. In the founding affidavit, the DA indicates that it had 3 weeks of engagements with the rest of the government to try and address this VAT issue, and they were unsuccessful. Consequently, accepting that it could not overturn that increase through those means, we submit that then the DA can resort to the courts.
So you're suggesting the litigation is frivolous and vexatious?
We are suggesting that the litigation is an abuse of court process.
Thank you.
No, I've got nothing.
Okay, thank you, Ms. Selo. Okay, anything else?
No.
I thought you were whispering.
It sounds like there was a bit of confusion about our head of argument. I just wanted to check that the court didn't receive.
Yes, we did.
Thank you, madam.
Thank you very much. Ms. Pillay.
Thank you, madam.
Thank you. It's now 3:05, so you have until 4:05.
Thank you very much. I'm engaged to the court. Members of the court, there are 4 issues I intend canvassing in our argument. The first is the process that is adopted by the finance committees, and as we understand it, that's one of the legs of challenge. The second is whether the report that was ultimately accepted met with the prescribed threshold in Section 8.4 of the Money Laws Act. The third is to deal with the allegations of substantive irrationality/deceit as a basis on which to set aside the decisions. And the fourth is to deal with the question of remedy in some documents. Members of the court, let me ask that the court go to Parliament's answering affidavits. It's 05, and can I have the same as 0560?
Oh, 516.
0560. And there, Parliament sets out in some detail the process that is followed in the adoption of the Finance Committee reports. I'm going to spend a few moments, Justices, going through that process, and I do so in order to meet the challenge of the so-called procedural deficiencies. As the court will be aware, it's common cause that there was a joint meeting on the 1st of April by both the Select Committee and the Standing Committee. The court will also be aware that there was a draft report, what we refer to as version 1, that was presented at that meeting, and that draft report appears in the DA's affidavit as a 10-point point. It's 02-99, and that's 10 points. The court will also be aware of the explanation given by Parliament that the members at that joint meeting at 37.3 went through each clause of the draft report, they deliberated on it, and they proposed amendments to it. And it's common cause that those written amendments were not effected at that joint meeting. The court will also be aware that the DA, EFF, and MK proposed or tabled specific alternative proposals. And the court is aware that Action SA tabled a very specific proposal. And can I have the court have careful regard to 37.6 of Parliament's answering material. It says there that Action SA tabled the proposal for the draft report, which included the fiscal framework and revenue proposals, to be accepted with recommendations to the Minister. The proposal was moved by Gansey, it was agreed to, and seconded and agreed to by the majority.
Is it not slightly different, Ms. Pillay? Sorry, I'm interrupting you in your 10 minutes.
No, not at all.
It was that Action SA expressed it stated expressly that it was against a VAT and tax increase and that it would support the report subject to the strict condition that.
And I'm going to take your ladyship through to the report as to where that's reflected. But for the moment, I'm going to ask the court to have regard to 10.1 being the initial report that was tabled, and 7.2 and 8.2 to Parliament's affidavit being the final reports as tabled. And I'm going to come back to that in a moment, Justice Savage. And then, if the court is to listen carefully to the video recording, the YouTube recording of this, which the court will do in course, the chairperson specifically sought clarity from Mr. Beasley as to whether Action SA was moving for the adoption of the report with those recommendations. And Parliament says a viewing of the footage shows that this was confirmed by Mr. Beasley and the timestamp is given. Then, members of the court, you have been taken to the issue of the voting in relation to that report. And if I can ask the court to then have regard to the way in which the proposed amendments occurred. In relation to the Standing Committee, that's dealt with at paragraph 38 of Parliament's affidavit, where members were requested to send their proposed amendments on version 1 to Parliament's support team, and the DA, EFF, and Action SA sent their proposals by WhatsApp, MK sent it by email. So there's a written record of what those amendments were. Parliament then quotes them at paragraphs 39 through to 42 of its affidavit. And then Parliament explains that those were then sent through, and at paragraph 43 of Parliament's affidavit, those were then sent through to the chairperson and the process that then followed. Parliament explains quite specifically that at 45, that there was a version of the report that had been published, it's version 2, which is attached as AA5 to Parliament's affidavit. Following that publication, Mr. Wickham sent this report as published to members of the Standing Committee, and Action SA raised a concern about it. Parliament says at paragraph 47, it effected Action SA's proposed amendments, and it then goes on at paragraph 48 to speak to where in the report they were. And then if the court can have regard to, I think before I come to the final thing, if I can ask the court to have regard to 0531 at paragraph 80, where Parliament says the DA, NKP and EFF rejected the report. The following parties voted in favour of it: ANC, Action SA and IFP, and as a result, the report was adopted by the requisite 6 members to carry it through. That was the majority. And then, if I can, apologies for doing this, but if I can ask the court to turn back to 05-24, and that's where the final report concludes by saying, having considered the fiscal framework and revenue proposals, the Standing Committee on Finance accepts the fiscal framework and revenue proposals. The DA, NKP and EFF reject the report. And then the process, members of the court, is also explained in relation to the Select Committee. That starts at 0525. And the result appears in paragraph 63, where it says that the proposal as reflected by the Select Committee or the resolution is then quoted there. Having considered the report of the fiscal framework and revenue proposals, the Select Committee accepts the fiscal framework and revenue proposals. The 3 parties proposed amendments to the fiscal framework. And I know there's a quibble about
your 10 minutes is up, Ms. Pillay.
whether there was a rejection by 3 parties or whether there were amendments to it. I'm going to have the court just have regard to those proposals as put up by the different parties. They appear at paragraph 39 and following of Parliament's answer. So, if I can then tie that up by asking the court to go to AA 2.2, which is at 0583, which is the agenda to that meeting. And the agenda made it clear that it was a consideration and adoption of the committee report on the fiscal framework and revenue proposals. The court will then have regard to the draft minutes that appear at AA 3.1 and AA 3.2. That's at 05-84. And the court will see there that at 0585, last paragraph, after deliberating on the report, these parties proposed amendments. However, the proposals were not agreed to by the majority of the committee. And the court will see over the page the report was duly adopted by the majority of the committee to accept the fiscal framework and revenue proposals. And so if one looks or listens to the 8.5-hour record of that meeting, there are parts that are difficult to understand, there are parts that are difficult to follow. But the following is clear. The report was put to the meeting, it went through, members of the meeting went through that report clause by clause, and there was ultimately a vote in relation to the adoption of that report. That vote was carried by the majority of members.
What was voted on, Ms. Pillay?
The adoption of the report.
Which report?
And it was so Madam, that's perhaps let me go there. So your ladyship is aware that the version 1 was presented.
Yes.
Your ladyship is aware that they were that report, the committee went through that report on a clause-by-clause basis.
Yes.
And amendments were put to that report. There's a track version of it somewhere in the papers that your ladyship has.
Yes.
And those amendments were not reduced to writing in that meeting, because as Parliament explained, someone was sitting there and taking notes. After the meeting, the amendments were effected. But what was put to the vote was the report as amended through the verbal discussions that we had.
Where does it say that? Because it seems that what's put is the adoption of the report, and the report that's before the committee is a draft report, which is then subsequently amended.
Yes. If I can just, if your ladyship will bear with me for a moment. At 37.6, where Parliament talks about the proposal by Action SA, and I just quoted whether Action SA was moving for the adoption of the report with those recommendations.
So is that now version 1 or version 2?
It was version 1 with the recommendations as presented during the oral engagement at that meeting.
And the other recommendations that were made?
With the recommendations. And I'm going to take the board to it because there's no, this is an important point, there's no debate that the report, let me have the report go there, it's AA 7.2. And it appears at 05355. I'm going to ask the court to go in particular to paragraph 6.26 and following. It's at 05-364. The SARS and revenue proposal.
So it's 05?
05-364. At 6.20, so under the heading in SARS and revenue proposals, there's a discussion in relation to the tax gap. And apologies, if I can just take it a step back there. The court will have regard to the heading, which appears at 05-360, which says Committee's observations and recommendations. And then it goes on to deal with the economic performance and outlook. And then just above the heading, just above 6.8, there's a heading that says fiscal framework. And then just above 6.26, it's the SARS and revenue proposals. And if the court would
Sorry, 6.20?
Above 6.26 is the heading that says SARS and revenue proposals.
Yes.
And then if the court has regard to what's said at 6.28, the committee notes the proposal to increase the VAT rate by 0.5 percentage points in 25 and 26, which will take the VAT to 16%. And then the committee further notes the following. And if I can, then, Justice Savage, to your point, draw the court's attention to exactly what's said at 6.32. That's the Action SA's proposal. The fiscal framework tabled by the Minister of Finance is supported, subject to the strict condition that National Treasury facilitates receipt of substitute revenue proposals from the committee. And then it goes on. Furthermore, at 6.33, that's also part of Action SA's proposal.
But where is it recorded that Action SA stands against the VAT and tax increases? That's at 7:30:04 of the record that was sent to us over the lunch break.
If your ladyship will bear with me, I'll get to it in a moment. Malady, if I'm going to.
Because what we've got here is not being recorded.
I'm sorry.
What Action SA said was not recorded here.
Madam, all I can say is that the Parliament's given the explanation as to how Action SA's proposal came to be recorded in the report. And there was an earlier version of it, which there was some difficulty with, and this was the final version of it. So there's no.
But does this properly reflect what is approved? Because it expressly states at the meeting, we stand opposed to the VAT and tax increases, and then that they would approve the report subject to strict condition that's then set out at 6, as is set out at 632.
Yes.
That's the basis on which they'd accept that.
Yes.
Is it not important to reflect that they expressly stand against the VAT and tax increases? Because the implication of the strict condition seems to be that they are labouring under the misconception that what is going to occur is that over a 30-day period there's going to be a debate about what the appropriate way forward would be. And that point is raised, in fact, by various, as I can see it, various of the members, the EFF member of the committee, the NK party member of the committee, and so on, that these issues are not properly recorded and we're not sure what we are approving. None of this is recorded in the report.
Yes. Madam, I stand for saying that Action SA specifically approved its proposal as captured in the report. I can't take that any further. Had it been of such a nature, and what's also of significance, the court will note from the papers that Action SA's initial proposal was to move for an amendment of the fiscal framework. Action SA later shifted from that proposal.
And what was that proposal?
I'm sorry?
What was that proposal?
What was that?
Yeah, from Action SA, ultimately.
So it was initially an amendment to the fiscal framework. It shifted from there to accepting the report as it is, subject to the inclusion of its recommendation.
And what was the recommendation?
As reflected in the report, Madam.
Well, that's not what Action SA said.
Madam, with great respect, that's what Action SA in the process as to how these reports were finalised. I've taken the court through to it.
I think my brother is referring to the recording. That what was in the recording was not stated in writing. Or rather, what is in writing is not a reflection of what happened at the meeting itself.
My lady, I don't...
And this is under your heading of at 05360 Committee Observations and Recommendations.
Yes, that is. But my lady, I refer to what's been said at 37.6, my lord, sorry, at 0517. I've taken the court there already. And the fact that at paragraph 38, where Parliament says in terms, the DA, EFF, and Action SA sent their proposals to the parliamentary support team on WhatsApp, and this was the proposal as reflected.
But is that not a proposal in the context of an opposition, an unequivocal opposition to the VAT hike?
My lady, I've pondered this long and hard because I see the counter-argument. The counter-argument would be, well, how can it be said that the fiscal framework is to be accepted in light of the alternative proposal that Action SA made? And I can't take it any further than to say this. On the sequence of things, the initial proposal was a dead right amendment to the fiscal framework from Action SA. There's a shift from there to an adoption of the report with a recommendation. Now, our learned friends make a lot about the question of the recommendation. I'm going to come to it in a moment. But it's really, all parties saw it as a non-binding recommendation.
But now, its adoption seems to reflect the expressions that were made by the committee of non-acceptance of the increase. Because if you look at the report and read it, you'll see it's not just the noting, although it says we note, but the expressions that are there are very strongly much against. And that's why, at the end of the day, there's an adoption of that recommendation to reflect the discomfort of the committee with that. So can those things be together? Can you accept, but at the same time say, go and think about it further and then come back to us in 30 days' time?
Yes. So Malene, I see it in the following way. There was an acceptance of it. There was an alternative recommendation that was put on the table, I actually say. Clearly, I don't want to trample on the minister's approach to any of this, but clearly that recommendation was there. It could have yielded one of two outcomes. It could have yielded an outright rejection of what had been adopted in relation to the VAT hike, in which event a different process would have commenced. Or it could have yielded no alternative to the VAT hike as proposed.
So it was in between. So is it not ambiguous? Because it's in between accepting and rejecting. So it took the midstream of saying, okay, go think about it and come back in 30 days. So isn't that ambiguous?
I submit not, because I submit that had there been an alternative that came up in those 30 days, then of course one would have had to have rolled back the clock around, and one simply couldn't carry on with this. Other than, or instead of there being, if there wasn't an alternative, then it would have been this fiscal framework as adopted that would have carried the day. And I submit with great respect, Malene, much of it turns on how the parties themselves actually understood this. If the court would bear with me for a moment. So we've made the submission that by virtue of having adopted the report, these committees adopted the fiscal framework.
Can I just ask a further question? When the section says there must be a clear statement, does it mean one line that should be read that we accept? Or does it mean you read the report as a whole and that must constitute the statement, or that must support the conclusion or that statement that's made?
Yes. So my lady, there goes a very difficult question. I'm going to come to that in respect. I think it straddles, as your ladyship points out, perhaps at two lines. The first is whether or not it met the defining threshold under 8.4 for a clear statement. And the second is whether or not it resulted in a substantive irrationality to the outcome. And I would submit whether or not, on the first point, whether it met the threshold under 8.4, I would submit that one has to look at the report, obviously, overall. And what certainly on my reading of that report, it reflects that there were concerns raised in relation to the VAT hike. There's no two ways about it, there were concerns. But overall, the way in which it was managed was with a recommendation that came from Action SA to look at alternatives. If no alternatives carried the day, then the fiscal framework as it was the fiscal framework.
But there was no intention to even look at those recommendations. I mean, the Speaker was alerted of the problems, the committee secretary was alerted of the problems the same day, the EFF sent a letter to the Speaker the same day, the DA the next day, to say, look, we've got problems with this report, and it was pushed through to Parliament. There was no intention to engage with the 30 days. So at least on the face of it appears that Action SA naively thought that its strict condition was going to get even the most basic time of day. It was never anybody's intention. The purpose, which was simply to force it through. And if you look at the record, the chairperson of when Mr. Molefe says at 7:47, what are we adopting? Because the report has changed so many times and we haven't seen the report. The chair says, let's proceed. And he wants an adoption. Then when the letters, the same day when the political parties contact the secretary of the committees and say this doesn't reflect what we discussed, The letters are then sent to the Speaker. It's literally pushed through. And what's quite extraordinary is that it didn't have to be. You could have, if the process, the Speaker, your client, could have slowed the whole process down and said, let's make sure we're all on board. We've got a report. This is an issue of national importance to every single person in the country. Let's make sure we're not seen as pushing this through with undue haste, and that we've dealt with all of the concerns that have been raised. But that was not the approach taken. In fact, it was the contrary approach. And one has to ask why. Why is there such a reluctance to engage either with the strict condition or to have the minister consider other options? Why is this no taxation without representation consideration just given short shrift?
Pillay, I can't say anything beyond the fact that the Action SA proposal, as it was sent to Parliament, is what was incorporated into the report. If the court is to find ultimately the report read as a whole doesn't meet the clear statement envisaged by 8.4 of the Money Laws Act, then I have to accept that that's the end of it in relation to this report.
I think my sister raised an important issue also, that if not all members are on board, meaning not everyone understands what is being voted on at that point, and then it simply is adopted, does that not taint the process?
Yes. So, Malek, that's a particularly difficult issue in relation to politics. And I say that cautiously because if the court is to listen to that record, it's clearly a large part of it is around political posturing. And it does raise the question as to what is the appropriate threshold, the appropriate point at which a chairperson can say, I've formulated the correct question, I've asked it, I've put it to the vote. The committee has spoken, and I'm carrying that. And I would submit, and certainly
Ms. Pillay, that is one way of looking at it. There's also another way. In particular, if you have regard to all the questions that have been asked by the MKP, Mr. Brian Molefe, Mr. Burke, then it's Mr. Van Rooyen of the MKP again, then Mr. Molefe again. The timestamp here that I've got on the record is 0947, paragraph 114.12. Mr. Molefe said that Mr. Beasley had stated as part of his motion that Action SA did not support VAT and asked whether that was part of what we have just adopted. So there was massive confusion. But why did the chair, as my learned sister has indicated, so adamant and eager to adopt this? For what possible reason?
Justices, I can't take it beyond referring the court to what I've said already. I'm not going to go there. The question was pertinently put to the committee as to what was being voted on, and there's a vote to that Parliament. And Justice Lepansi, one might say, I'm having looked at that, well, there was a thing between uncertainty, unhappiness, or whatever it is. But it comes down to the question of what was the question that the chairperson put to the committee, and what was the process around that? On an 8.5-hour long meeting, what happened in hour 4, what happened in hour 5 when it's overtaken by something at a later stage, I submit with great respect ought not to carry today.
Do you accept, Ms. Pillay, that the report that was put before the committee and was voted on is not the report that was then placed before Parliament?
No, perhaps I'm not being clear, Justice.
No, you are making the physical report that was put before the committee.
Yes, but of course, the physical report had been overtaken by the amendments that occurred in that.
So, you're saying the report plus amendments was being voted on, although there's no reference to any more than the report is adopted.
Yes.
So the physical report that was before the committee is not the same report that was placed before Parliament the following day.
Yes, because I've explained to the court what the process was in relation to that. So if you could bear with me for a moment.
But is that not a problem, that you've got a physical report voted on, which was placed before members of the committee? They weren't recalled to consider an amended report and to then vote on the amended report to determine whether they accept or want to seek further amendments in terms of 8.4 to the amended report. But rather the first report that was placed before them is, a vote is forced on that report. That report then has to be amended because it's not in the form that it was placed before the committee is capable of being put to Parliament, because it doesn't achieve the purpose that 8.4 requires. So even if it was approved, the approved report doesn't meet the requirements of 8.4.
So there are a couple of questions your ladyship's put to me there. Let me take it in turn. Question one, as a matter of principle, is there anything objectionable about draft one of the report being put before committee, amendments being effected orally to that draft, and the amendments subsequently being reduced to writing and the written document being put to Parliament? And I would submit with great respect to that process itself, there's nothing objectionable.
Is that not fact dependent though? I mean, one can't say as a matter of principle, of course, and I raised that, I think, with Mr. Ngcukaitobi,
Yes.
that certainly there'll be circumstances where an amendment post to votes might be agreed by everybody, and that's fine.
Yes.
But there'll be other factually where that is not supported.
But for the moment, let me just put it, and certainly on the facts of this matter, my submission is there's nothing objectionable about that as a process, and there's no procedural requirement, whether it's in the rules, whether it's anywhere else that our learned friends have pointed to, that hasn't been met by virtue of that process. It then appears to me, Justice Savage, the next question is the report as amended in writing, pursuant to that meeting, does that reflect an accurate amendment of what's actually occurred? And certainly insofar as the proposals by the three parties went, Parliament's explained the WhatsApp messages, the text messages attendant on which those amendments were effected. So my submission is that there can't be any serious challenge that the counter proposals that were put up by the other three parties don't reflect what they had intended for.
But Mr. Pillay, the amendment that was proposed by Mr. Beasley
Yes.
from Action SA, that's not being reflected in the report properly.
Why does your lordship say that it's not reflected in the report?
Because if you have regard to what they proposed, if you go to paragraph 40 of, I think it's the Speaker's Fani papers.
Yes. The Speaker's
Answering papers. At paragraph 40, it clearly states what Action SA is proposing.
Yes.
But that's not being reflected in the final report. That was before Parliament.
My Lord, if I can draw your attention to
More importantly, at I think it's timestamp 072958, Mr. Beasley clarified that Action SA stands against any VAT and tax increases.
Yes. And if the court is to look at that as against 05-366 and 367.
Zero 5-3
66 at 6.32 and 6.33.
Yes.
And that's where it's been amended to be incorporated. And the court will also have...
Sorry, where do you say it's incorporated?
6.32, subject to the fiscal framework tabled by the Minister of Finance, is supported subject to the strict condition that National Treasury facilitates the receipt of substitute revenue proposals from the committee, together with corresponding expenditure savings that will form the basis of an alternative revenue proposal instead. And then it goes on. So that is the Action SA proposal.
What was the meaning of that amendment? That, I mean, what is the meaning of that supported subject to strict condition? What is your understanding of the meaning of that? I mean, it was not an amendment to the report. It was just a point of interest.
Sorry, Justice Savage, perhaps there again, the conflation, and I accept because of the way in which this panned out, but there was the report which was amended. The imperative for the committee was an adoption of the fiscal framework, an acceptance of the fiscal framework, or an amendment to the fiscal framework. And we've taken the court through in our heads of argument as to the sections in section 6 of that report where the summaries around the fiscal framework has been provided. And certainly on my reading or listening to that recording, I certainly don't come to a conclusion that the substance of what Action SA proposed was an amendment to that report. And
so what is it then?
It was a recommendation. And it was a shift in Action SA's stance, and it was, and perhaps I can do it this way, Justice Savage. If I can ask the court to look at our heads of argument. And perhaps my learned friend Dr. points out to me, the EFF's papers, I'm going to ask the court to go there, it says 07-15. Perhaps it might be helpful to start the page before, 07-14, where the EFF says, Action says Alan Beasley proposed an amendment.
Which paragraph?
31, sorry, my lady. Alan Beasley proposed an amendment to the fiscal framework, which he also texted or caused to be texted to the finance committees, including myself. The recommendation was that the fiscal framework by the minister is amended and it recognized, etc. in the entire. And the court will look at that initial proposal as made by Action SA and contrast it to the proposal that it ultimately submitted on this. And I'm going to then ask the court to look at our heads of argument.
So if I understand you, Action SA moved from seeking an amendment to granting approval subject to a strict condition, under the mistaken belief, somewhat naively perhaps, that this 30-day engagement period was going to ensue, when there was no intention to engage in that 30-day period, because the following day the report was placed before Parliament.
So, my lady, I'm unable to account for how Action SA understood it, and I'm unable to account for whether there was an intention to comply. I have wondered about what the consequence would be if subsequent to the 2nd of April, that engagement process took place and it yielded an alternative process, an alternative outcome to the 0.5% increase. And it seems to me that had that happened, then it would have been the subsection 6 amendment of the fiscal framework that would perhaps have had to go all the way back on it.
Is the use of report and fiscal framework synonymous for the purposes of your argument? Now, if that is the case, if the report is adopted with the amendments, would that not amount to an amendment of a fiscal framework?
Not at all. There are sections, my lady, in our heads of argument we've drawn it out, where the sections of the report speak directly to the fiscal framework. And there are other parts where it speaks to the public consultation process, the input from National Treasury, etc. But the submission is an amendment to a report doesn't result in an amendment to the fiscal framework necessarily.
So the adoption may not necessarily be the same. So the adoption of a report may not necessarily be the adoption of the fiscal framework.
Yes, but the submission we've made, Parliament's made in this, is that given the content of the report and the sections dealing with the fiscal framework, the adoption of the report amounted to an adoption of the fiscal framework. And your ladyship will see that's certainly how the DA understood it. If the court is to have regard to the DA's own proposal, which I've taken the court to in Parliament's answering affidavit, it spoke quite pointedly to the fiscal framework needing to be met.
Did the members vote on that statement to say that we agree to this statement, we agree to the amendment? So a certain part of the House says, or the committee says, we agree to the statement, we accept it. The other part says, no, we don't. Was there ever a point where that was done?
No, there wasn't, Judge President. So the way in which it actually worked was that it was the report with amendments that was put.
So it was assumed that, well, we've sent the amendments out, and that should mean that it's an acceptance of fiscal framework because only these three parties gave us the amendments.
Not at all, Judge President. At the actual meeting, in the last hour of the meeting, in particular, each of the parties, and with great irritation, read out their proposals word for word at the meeting. And attendant on that, the amendment as proposed by Action SA was supported, seconded, voted on, and it was then carried.
So each party says we accept, when they read their proposal, accepted three.
There was a vote that was, so the chairperson then put it to the vote and said, I now, and he specifically asks Mr. Beasley, do you accept the report with this recommendation? Mr. Beasley then affirms that that is in fact the case.
And everyone else?
I'm sorry?
And other people?
And that is then put to the vote, and 6 members, being the majority in the standing committee, then carry the vote on that.
But what do you make of the argument that was raised that the proposals or amendments were never shared with the committee members in written form?
So Justice Rakansi, again, we put the various timestamps in the affidavit, but the various amendments as proposed were read out, I don't think once, but twice in the course of that meeting. And so it's correct, there was no written record of what those counter proposals were that were being put forward, but they were certainly read out on my count more than once.
And the complaint that the question was never directly posed to the committees whether they accepted or amended the fiscal framework.
Yes.
What must we make of that?
Yes. So that is so the way in which I see it, Justice Rakansi, it's like this. The agenda to that meeting made clear that it was the report that was to be adopted.
Excuse me, that?
The agenda to the meeting.
Yes.
And it was AA 2.2 to Parliament's affidavit. There was then the draft report, and there was then a vote on the draft report as inclusive of the amendments that occurred. So it's correct, there wasn't a written record of what those proposals were in the meeting. That happened after the meeting when parties were asked to send their written records.
But then how can the members apply their minds to the report and vote on it?
So, Justice Rakansi, here's the difficulty, and the question does reduce to this. Was it impermissible for those amendments to have been proposed orally and for the adoption of the report to have occurred attendant on those oral amendments? And my submission is there's nothing in the rules or anywhere else that requires otherwise, and therefore there's no unlawfulness certainly arising from that aspect of the process. Justices, perhaps just to make this The DA itself recognizes that the recommendations made by Action SA did not have the effect of amending the fiscal framework. And if I can have the court have regard to our heads of argument at 12-32. And here says that the NA and NCOP met to resolve and adopt the fiscal framework. They say in terms, there's a very telling part which we've referred to in our heads, I can't find the reference here, but where Dr. Burke from the DA himself summarizes what the position was and what the import of Action SA's proposal was. And it certainly wasn't to amend the fiscal framework. If I can have the court have regard to paragraph 36.6 of our heads of argument. Where we say that the effect of Action SA's stance is that it was accepting the report, which included the fiscal framework. Dr. Burke from the DA understood it as such, and we have the reference to the timestamp.
But what's to be made of the express statement that they don't oppose, they don't stand, or they in fact stand against a debating this?
So that comes to what's the import, and I don't want to play clever lawyer in Justice Savage, but I do want to raise with this what then was the import of the recommendations that were made. And can I have the court go to 12-32 of our heads of argument, where the DA says there was this non-binding at 58.2, non-binding recommendation made by Action SA. The DA says itself at 58.3, that recommendation has no effect. It will not stop the VAT increase from coming into effect on 1 March.
But is it not a conditional adoption then? Is it not a conditional acceptance by the Action SA, at the very least, that this strict condition be complied with?
Well, part of the difficulty, Justice Savage, is what then is the consequence of that so-called conditional adoption?
Or can it be said that there's an acceptance?
And my submission is that provided, and again I don't want to repeat myself, but provided there was the condition of alternatives being looked at, and that would either happen or it wouldn't happen, but the point was that Action SA specifically shifted from saying it wanted to amend the fiscal framework to saying it was accepting the fiscal framework subject to his proposal being carried.
But Ms. Pillay, you would accept that there was confusion at least?
I'm not sure there was, and Judge President, I think it's tempting to say there was when one listens to that recording,
yes,
and one takes piecemeal snippets out of the recording. But when one gets, and we've given the court the timestamp of where Action SA's proposal was framed by the chairperson, there was confirmation sought as to what its import was, and it was put to the vote. And I would submit that given that both the DA and the EFF understood it as such, the EFF's parts we refer to paragraph 60 of our heads of argument, where it too says that it was a non-binding recommendation. And so what this court perhaps is left with is this question: can it be that the non-binding recommendations as put up by Action SA have the effect that it doesn't have the effect of amending the fiscal framework?
But what if Action SA and all the rest of the parties that voted in favour of it was of the view that in fact it is binding?
Well, that's not the case that, with great respect, that the court has before it. The court has two parties challenging it, and both those parties proceed from the premise that it's nothing more than a non-binding recommendation. And who knows if There were different challenges to it on different bases, but the submission is on the basis of a non-binding recommendation. It cannot be said that in substance the effect was that it wasn't a fair statement of having it.
But there must have been some confusion, because if one read the records and the conversation, it's quite clear that Mr. Beasley, who proposed the recommendation, if I can put it that way, he himself says he's against the increase of that.
Yes.
I mean, so what must we make of that?
So my look, I suspect that he does say he's against it. But of course, if he's against it to the extent that he didn't support the fiscal framework, then his initial proposal of having sought an amendment to the fiscal framework would have been the course to carry the day. And I accept, I've listened to that video recording many times, and there are many points at which parties say, well, we don't know what we're voting for, etc. And I submit with great respect that when the chairperson asked Mr. Beasley to confirm what it was, and he framed the question for the vote in the terms that he did, there could have been no confusion.
I'm not so sure. From where I'm sitting, I'm just saying
You're first.
Yeah. All right. Are you about to finish? I wanted to ask you a question on the relief sought, because in paragraph 9 of your heads, you say that the adoption of the report is neither a prerequisite nor a part of the minister's announcement to increase the VAT rates. The minister derives power to increase the VAT from section 7.4. Acting pursuant thereto, he made an announcement on 12 March, well before the parliamentary processes. In the circumstances, there is simply no basis that the order sought in relation to the Finance Committee. There's no basis for those orders, and that ought to be the end of the matter. That's what you say. The two questions is, what is the purpose of Section 8 processes if there is an unhinged power for the minister to go ahead?
Perhaps let me put it this way. It's a question I've grappled with long and hard. I don't purport to have a clear answer to it, but justices are reasoning it in this way. Can I ask the court to go to the Money Bills Act and section 7.1?
Section
7.1. And it says the minister must table the national annual budget in the National Assembly as set out in section 27 of the PFMA at the same time as the division of revenue and the appropriation. Now, the question then is, what standing does the fiscal framework on its own, without anything else, have in terms of yielding an increase in that? And the submission is that the statement made by the minister on the 12th of March obviously predated any parliamentary processes. But if the court is to have regard to Annexure DA4, let me start here by asking that the court have regard to 02-17, where the DA says, after explaining this process, a copy of the draft rates and monetary amounts and amendment revenue dated 12 March is attached as DA4. Clause 5 amends 71 of the VAT Act to provide for the 15.5%, which is deemed to have come into operation on the 1st of May. And if the court then has regard to that document at 02-64, and can I have the court return to 02-65? when one looks at the long title, it says, fourth line down, to amend the Value Added Tax Act so as to amend rates of tax and to amend Schedule 2 of that Act. And then the court will have regard to 02-67 and 02-68, where the amendments to Section 7 of the VAT Act are in fact effective. And so the submission is, Judge President, it's not an easy answer, but certainly on my reading of it, the Minister makes the statement, the statement then follows as per what Section 7.4 of the VAT Act says it does. But on the facts of this matter, the statement doesn't operate in a vacuum. The statement must be tabled together with a statute. That statute was tabled as a draft or whatever it is on the 12th of March, and it is the statute that gives the teeth to the increase. And so certainly the way in which I have it is that the Minister's statement up until the point at which the statute is adopted then carries the day, and that must be the consequence of 7.4 as it stands, and provided the statute is then carried, or whatever happens with the statute, that would then result in the process.
I know you are abiding on the issue of constitutionality, or rather on the attack against the minister's decision. But I just wanted to ask a question that we've asked to the minister, that if Parliament is not happy with the increase and it imposes or it amends the fiscal framework by introducing its own increase after assuming that the process is followed properly, and then it's tabled, and at the tabling, the adoption of the report is with the amendment to 0.4, which is a number that we debated around. Now, and the minister comes back saying, no, I don't agree. The announcement goes through. Is that what is the situation? What would carry the day?
I must be careful to stay in my lane, but in direct response to the court's question, I would make the submission.
So doesn't that interfere with the broad powers of the legislature? I know that's not your terrain, but now you are the legislature standing there, and so at least you can give us an answer on that issue. Doesn't that constrain the powers of the legislature in this instance?
I do see it as that, Judge President, and I see it in the following way. Section 7.4 of the VAT Act gives effect to the minister's announcement.
Isn't that problematic potentially?
Judge President, you're drawing me into terrain that.
But yeah, as the legislature, I mean, obviously, I know that you haven't prepared on this point because that's not the point that you had.
I would submit that when one is engaging with the challenge of unconstitutionality and a potential overreach of 7.4 as regards the minister's powers, one would have to have careful regard to what the purpose of that power is, what the duration for the exercise of that power is, and what is the effect of that power if there were to be a statute like TA4 that were to be adopted in the scheme of.
I think the second reason why I'm asking the question is based on the fact that if we set aside the resolutions and the reports and we remit it to the committees to start afresh, whether it will have any impact on its own on the decision of the minister.
I wondered about that, Judge President, and the fiscal framework does have relevance to, I think, its sections. If you bear with me for a moment. Sections 9, 10, and 11 of the Money Laws Act. And so it seems to me that it can't operate in this vacuum, so in the Court of England. And I'm asked, the court's aware, and I drew the court's attention to sections 9, which deals with the division of revenue bill, section 10, which deals with the appropriation bill, and 11, which deals with the passing of revenue bill, section 11A, for instance. And the court will also have regard to 8, 9 of the Act itself, which says any amendments to the division of revenue bill, the revenue bills, or the appropriation bills must be in accordance with the estimates of revenue and expenditure, excluding statutory expenditure, etc., etc.
So they're not all interrelated. Is there not an interrelationship then between the annual budget and the fiscal framework and all these various stats for these pieces of?
So part of the difficulty, Justice Savage, is that I don't read the power given to the minister in 7.4 of the VAT Act to be reflective of this interrelationship. I read that as a circumscribed and definitive power given in relation to VAT rate, and I read other processes as in relation to division of revenue, etc. that it would be.
All right, my last question, and then, of course, if my colleagues don't have any, is that I'm just going to the EFF's issue, that Parliament had responsibilities beyond what it actually did to engage with the actually revenue proposals and the fiscal framework by the minister, not simply to say, well, that's the minister's role, and and then that's where the constitutional challenge, if I were to put it that way, or that's where the implication of the Bill of Rights is put in. That you can't on the one hand say we are so concerned, but yet just leave it like that and say, well, that's the minister's role.
So I understand, and that was the last item on my list that I intended addressing, so let me deal with it briefly. Judge President, I think, with great respect, it would take a very brave court to reach into the argument that the EFF has presented on that.
Excuse me?
A very brave court to reach into the argument that the EFF has presented on that score. And I say that because this is an urgent court we need to determine final relief on an urgent basis. These are manifestly complex issues and questions as to whether substantive equality rights have been breached or not, based on a particular paragraph or an alternative paragraph in a report that has been adopted, I would submit is terrain that stretches too far for it.
But at least the EFS is asking for interim relief, maybe just to correct you on that issue.
And I'm going to come to the way in which the EFS reliefs have been formulated. But what it does require is it does require this court, bearing in mind, and I'm not for a moment suggesting that separation of powers gives us a red flag and the court can never go there. But I'm submitting that on the submissions made to the court, it would certainly take a brave court to engage in whether or not issues of VAT increases are pro-poor, anti-poor, contrary to our notion of substantive equality or any of that. And I'd submit that it's with respect, it's equally unhelpful to engage in the question of substantive irrationality in what the EFF asks this court. And they're complex questions. You know, the one question is this a legality review or is this a pattern? Certainly insofar as what the finance committees have done. If it's a legality review, is substantive irrationality in the way that it's been contended for an appropriate threshold? And I would submit that these, with great respect, are inordinately complex factual issues and inordinately complex legal issues that certainly an urgent court would not be going. I'm going to then deal briefly with the question of the relief sort.
Can you do that in a few minutes? 2 minutes? 3 minutes? With costs as well.
Let me go just to... I'm going to go first to the DA's relief. Can I ask the court to go to 01-2 And the court will see that what's being challenged by the DA are the resolutions of the NA and the NCOP to accept those reports. And what they're asking is that they implemented. Now, I've already made the submission, and we've made it in our heads document as well. This is not a question of multi-layered decision-making. The principle is overview. The committee had to accept the report, or it had to accept the fiscal framework or amend it. The committee did just that. It accepted it. When it came through to the NA and the NCOP, it wasn't for them, and in spite of the letters from the DA and from the EFF, it wasn't for the NA to question the lawfulness of what has been presented. The NA was entitled to take the report as it was and to look at it and put it to vote. And I submit that ought to be the end of the matter. But in any event, even if
Could the NA amend the report?
certainly not on my reading of the statute, Judge President. And I tell you why. If I look at 8.6, it says, okay, 8.4, the report must have a clear statement except for amending. Then when amending, the process is governed by 8.5. And then it says, if the report includes amendments to a fiscal framework or revenue proposals, then these are the things that must happen around it. And I accept this clause may be susceptible to a reading that says that's only if the finance committee effect an amendment. But it seems to me that if the insight and input of the minister is required in relation to a finance committee amendment, it certainly ought to be required in relation to an NA or NCOP amendment. And so we submit that simply on Odicrol, our learned friends ought not to come home on the basis of prayer 2. In any event, even when one looks at the processes by the committee, they're by no means a perfect process, but there's been nothing to suggest that any rule, any provision was not followed in the process adopted. And
What is the legal consequence of that report, the legal effect of that report by the committee?
So our learned friends try and shoehorn it into the space of recommendations or investigations that are given in the context of multi-stage decision-making. We submit that it's a report, and it's a report that's been adopted by the finance committees, accepted by the finance committees. It doesn't have any legal effect other than for the acceptance that it's been accepted by. But I'd submit that that's not the threshold in terms of it ought to have been challenged at the earliest stage. Okay. And I've given the references on Magnificent Mile and
But what do you make of the argument by Mr. Bishop that if he would have come to court on that score alone, the argument could have been he's prematurely before court because Parliament hasn't even decided on the report.
Mm. And so, of course, then that would have engaged the debate as to whether or not it is open to Parliament to even amend the report as it comes in. And in any event, there's nothing to prevent the DA from raising that challenge as a frontal attack in this litigation. That's not what they do. And so that's the submission. The Nito sort out, and then when someone begins argument, well, you know, everything's before court and you can simply set aside the finance committee's decisions around it. We submit on a case of this scale and implications of this nature. That's not the way in which a challenge ought to operate.
But the EFF have challenged the...
I'm going to challenge the EFF's challenge now. So the EFF says that they're asking for a suspension of the report pending the finalization of the document. And the court knows full well that suspension relief is in fact appropriate from EFF versus Gordon. And the question is whether or not the case as made out by the EFF falls into the threshold of a just and appropriate. And we've dealt with this at the tail end of our original heads of argument, and our submission is having regard to prospects of success, having regard to consequences for the fiscus. And parties here will try and make the argument that it is actually an irreversible consequence for the fiscus in terms of funding that's lost, in terms of government priorities that it will certainly have an outcome effect. And I would submit, in light of all of that, a suspension order in the terms sought by the EFF ought not to be granted.
Costs, you done?
If your ladyship will be with me. Much of this case has been framed on after the fact statements that have been made. And I would submit with great respect to the court's task is to determine whether or not the process that was followed by Parliament was a lawful one, and secondly, whether the resultant report met with the legislative precedent of what we needed to have. Whatever political parties say after the fact in the space of politicking ought to be areas that the court doesn't draw inferences from. And on the question of costs, members of the board, that's something that Parliament will abide. The case law is what it is on it, and we will leave it in God's hands.
All right, thank you.
Those are my submissions. I'm indebted to them.
Thank you, Ms. Pillay. Mr. Bishop,
Yes.
how much time, what agreement have you come to with the EFF? Should we give you 15 minutes each?
I'm going to have 20 minutes.
20 minutes.
And my learned friend is going to have 10.
10 minutes, okay. We'll hold you to that.
Hopefully I'll be less.
Please.
Maybe, so I wanted to start with an important issue that had the attention of the court and which cuts across both parts of the case, which is how does the fiscal framework affect the minister's announcement to increase the VAT rate under Section 7.4? And so this could come up in two situations. The one is the one the court has been debating. If Parliament had adopted a different VAT rate, the 0.4, what would that have done to the VAT increase? Or if this court sets aside the fiscal framework, but doesn't say anything specifically about the VAT announcement, what would the consequence of that be for the increase in VAT? And our view on this one issue, we agree with the Minister and with Parliament about the effect of Section 7.4. Because the way we read it, the last part of Section 7.4, so this is on page 2 of that bundle, it says that alteration will be effective from a date determined by the Minister in that announcement and continues to apply for a period of 12 months from that date, subject to Parliament passing legislation giving effect to that announcement within that period of 12 months. So our view is that it will come into effect even if the fiscal framework rejected it completely or adopted a different one. It will still come into effect on the date of the announcement. We say that for two reasons. The first is that it permits the Minister to announce a date before the fiscal framework. So he makes the announcement on the 12th of March. He could have said it will come into effect on the 13th of March, long before Parliament will get to the fiscal framework. Nothing in Section 7.4 prohibits him from doing so. It's not linked to the Money Bills Act. And the second reason is because Section 7.4 refers to passing legislation, not just Parliament by resolution accepting, which might fit with the fiscal framework. So your Ladyship Presiding called it an unhinged power, and we agree with that. We submit that this is part of the reason why Section 7.4 is unconstitutional, because it comes into effect and Parliament cannot stop it except by amending Section 7.1. So that is our view, and that's why we submit we're entitled to the relief we seek against the Minister, because Section 7.4 is unconstitutional, and this permits immediate, irreversible imposition of a tax. But we agree that it would be better if Section 7.4 was linked to the fiscal framework. You'll see in the letter that my attorneys wrote to the Minister of Finance, I think it was on the 18th of March, it's DA6, it appears at page 02-86. that we put this position to the Minister and to the Commissioner. And what we say is, surely, if Parliament rejects the VAT increase in the fiscal framework, obviously you must accept it won't come into effect. We never received an answer to that letter from either the Minister or the Commissioner. But we put that to them. And we said, because substantively, purposively, surely that must be the position. It doesn't make democratic or constitutional sense. But we don't think it is the position, because it's not compatible with the text. And the way to fix the problem is to declare the section unconstitutional, not to give it a reading the text cannot bear. But if we're wrong, and the court is with my learned friend Mr. Ngcukaitobi, and it says that the two are linked, and if the fiscal framework doesn't adopt the VAT increase, then the VAT increase cannot come into effect. Then the hypothetical question the court has been debating about if Parliament adopted the 0.4% doesn't arise. What arises is if this court sets aside the adoption of the fiscal framework, either interim or final, but either way, it suspends it or it sets it aside, but it doesn't say anything separate about the VAT increase. What is the consequence? So as I understand Mr. Ngcukaitobi's argument, the consequence would be that because Parliament has not yet accepted the fiscal framework, it cannot come into effect. And we don't think that fits with Section 7.4 because it's not contingent on positive action by Parliament supporting it, and it must be by legislation. But if the court wants to go in that direction, the one submission we would make is on remedy. That it would be very important to be clear about this and to give a remedy that makes it clear whether or not the VAT increase is going to come into effect. And if the court is going to suspend it, pending what? Pending Part B of the DA's challenge to the constitutionality of Section 7.4, pending reconsideration of the fiscal framework by Parliament, what is it suspended pending? So, of course, my submission is it should be suspended pending the outcome of the challenge to Section 7.4. And I stress that doesn't prohibit Parliament from adopting it. That just stops the Minister's announcement coming into effect. It would still be open to Parliament to pass the bill before it and give effect to the 0.5 increase. And nothing we're asking this court to do will deny Parliament that power. But it'll be pending the outcome of Part B. So I hope that sets out our position with regard to that question of how Section 7.4 operates and interacts. I then want to deal with the Minister. I'm going to spend most of my time with the submissions made by my learned friend, Ms. Sello. I think there were two important concessions that were either made or repeated. The first is in response to questioning from Justice Savage, the concession that this is a revenue-raising mechanism, it's not regulatory. And the other is that as I understood my learned friend's argument, she conceded it is an amendment to Section 7.1. She said at one stage that the announcement, quote, technically amended Section 7.1, and at another point, quote, it has already amended the Act. So that's contrary to what's put up in the answering affidavit and in the heads of argument, that this is not an amendment. But I think the concession was correctly made, because it can be nothing but an amendment. The next point I want to address is an argument made with reference to the first certification judgment that separation of powers is not absolute. And of course, as a general principle, that is correct. But in this particular area, the Constitutional Court has dealt with where the line lies between the legislature and the executive. And here, on taxing power, revenue-raising taxing power, it's drawn a bright line. So in other places, it can be mixed and it can be context-sensitive, but here, the court has drawn the bright line. I then want to deal with the argument that it's not, this is different from casino association or club, because this is not the imposition of a tax, it's just the changing of the rate of tax. And so I've got three reasons that's wrong. The first is that it's inconsistent with casino association, because as I pointed out in my main argument, and this appears at paragraph 14 of the judgment, where the court sets out how the Northwest statute works. And there's one provision, page 22 of our bundle. The relevant provision that gives effect reads, a holder of a license shall be liable to, at such intervals as may be prescribed, pay a gambling levy. which shall be calculated on such basis and at such rate as may be prescribed. So it imposes the obligation, it shall be liable for a levy. That's in the Act. And then the Act allows the minister to set the rate, which is exactly the same as what we have here. Yes, there is also a percentage in the legislation, but the minister is given unlimited power to change it. He can change it 1 year to 0%, the next year to 16, the next year to 13. It's almost virtually the same as a power to just set the rate. And so it's substantively identical to casino association. So that's the one issue. The second issue is if one looks at the test, the way that the Constitutional Court has framed it, and I refer the court particularly to Shuttleworth at paragraph 42, where the court says, it is the people through their duly elected representatives who, quote, who decide on the taxes that residents must pay. And then it says, an executive government may not impose a tax burden or appropriate public money without due and express consent. So it's not about imposing a new tax. That's never the language that's used. So, oh, well, you can change taxes, but you may not impose an entirely new tax. It's about the decide on the taxes residents must pay and the tax burden. And if you're increasing the rate, you're increasing the tax burden, you're changing the tax burden for residents. The final reason that this distinction makes a difference is it's inconsistent with the underlying principle. The principle, the reason the court has established this rule is no taxation without representation. And I think that quote, I think, goes back to the Boston Tea Party, and I think the revolutionary Americans would be quite surprised and said, well, as long as King Charles is not imposing a new tax, you have nothing to complain about. Because he's just increasing the rate, that's fine, as long as he isn't imposing a new tax. People are upset about taxation without representation because they have to contribute more to the common welfare without feeling that they've been heard by their representatives, that their voice has been heard. And that is the case whether it's an increase, a decrease, or a new tax. I then want to deal with, in questioning, I think my learned friend conceded that there's no constitutional court case that supports this position, that we distinguish between changing a tax and imposing a tax. The closest she came was to rely on the judgment of Justice Rogers in Africa. And there's a part there where he lists various sections, including section 7.4. But as the court pointed out, that reasoning was not adopted by the majority. It's inconsistent with the majority. And you've got to read with Casino Association and Maklaba that were unanimous and come after Africa. So really, the judgment of Justice Rogers is interesting, but has no precedential effect. My learned friend then referred to 2 Pioneer Foods cases, and neither of them are relevant at all. What they're about is compelling the Minister of Finance to issue regulations adopting tariffs under the Customs and Excise Act. Neither of them has a challenge to the Constitution. So they're trying to give effect to the delegation power. They're saying, Minister, you must use this power that has been delegated to you. Neither of them have a constitutional challenge to the legality of that delegation to the Minister. So they're completely irrelevant. They don't engage this issue at all. And so in these circumstances where there's clear, recent, repeated constitutional court authority that supports the DA's case, and not a single judgment that supports the Minister's case, we have at least shown reasonable prospects of success in Part B, at a bare minimum. I would say we've shown very strong prospects of success. That brings me to the argument about the meaning of subject to, and the fact that there's some form of parliamentary oversight in the reference to Zanzi and Morowane. So, as I understood the Minister's position, he accepts that until legislation is passed, the announcement will be in effect. That from the date that the Minister chooses, until legislation, the VAT rate will change as the Minister decrees. And there's nothing that can be done about that. It can never be reversed, it can never be changed by Parliament during that period. And so, to the extent there is some oversight, it can only be oversight from that point onward, because it's impossible for Parliament to undo what the Minister does. So that's not really oversight, that's just saying, well, you can stop it at a point, at some point, if you act. But it's not oversight because it doesn't require approval to come into effect. It comes into effect without approval, and and as we discussed earlier, even contrary to Parliament adopting a fiscal framework excluding it. So even if Parliament expresses its democratic will and says we don't want an increase, it will still come into effect. That's not parliamentary oversight. The argument was then made that Section 4 is constitutional because it affords Parliament the power to stop the increase. Parliament doesn't need Section 7.4 to give it that power. Parliament always has the power. The Constitution gives it the power to change the law. It doesn't need to enact the statute to give itself the power. So it's meaningless to say Section 7.4 gives the Parliament always has the power to change the law. What that really is a concession that what the Minister is doing is lawmaking. Lastly, to deal with the Minister, I want to deal with the issues about the costs or the dangers of suspending the VAT increase. So the one that was mentioned is, if we don't get the 13 billion, that will increase the risk that we'll need to borrow money, might increase the cost of borrowing money. But this is merely asserted in the answering affidavit. It's just stated in one or two paragraphs. No explanation is given, no details at all about how losing just 0.1% of revenue is going to create any real problem for borrowing. And importantly, the argument about the lack of revenue is not a cash flow problem. The Minister doesn't say, we are running out of money in the National Treasury. We need that which we collect monthly. We need that to pay now. I can't pay doctors and teachers next month unless I get that. That's not the argument. There's no fiscal cliff which has to be filled by the immediate collection of that.
When he says there's a deficit.
But it's a yearly deficit. So it's a deficit that's going to occur if we don't collect 13 billion. We spend the amount that he's proposed, and we don't find some other way to collect the 13 billion. By the end of the year, we will run out of money. But he's not saying we're going to run out of money today or on the 2nd of May. That case is never made in the answering affidavit. So there is time to fill the 13 billion rand hole, either by reducing expenditure or finding alternative revenue. And I didn't hear my learned friend to explain why the alternatives that are identified in the committee's report are not viable. And I didn't understand my learned friend to explain why, if Parliament decides to decrease expenditure by 0.1%, that will have catastrophic effects, if Parliament decides to do that. So we submit on the VAT part of the case, we made out the case for suspension, that the harms of allowing the immediate increase on the poor, on the vulnerable, on all South Africans, outweigh significantly any limited financial risk for business. That brings me to Parliament, and I need to correct an error that I made in my submissions earlier, and this is about the Action SA submission, because the problem is there are two final reports on the record. There's the final report that we attach to the founding affidavit, which is FA 13. And that final report refers to a recommendation of the Action SA proposal is couched just as it has recommended that. And then there's the final report that Parliament attaches to its answering affidavit, AA 7.2, which uses the strict condition language. So we were under the impression that our final report was the same as their final report. This difference is not expressly made in the answering affidavit, and I didn't pick it up, so I apologize for the fault. But it seems that the one attached to Parliament's affidavit is actually the final report. And that does have the strict condition language that was the language used by Mr. Beasley in the committee meeting. So that weakens one part of my case, but strengthens the other. It weakens the part of the case about whether what happened in the committee was accurately reflected in the report before Parliament. Because it seems that it was, although there were lots of last-minute changes going on, but ultimately it was accurately reflected. But it strengthens the other part, because what the National Assembly ultimately voted on, and the National Council of Provinces, was a report with the strict condition language. And for all the reasons I gave earlier, acceptance subject to a strict condition can never be a clear statement accepting or amending, because it necessarily means that the acceptance will lapse if the condition is not met.
But now that was changed to recommendation, as I understand.
So it wasn't. So there were two versions of the report after the meeting. The first version of the report after the meeting changed it to recommendation, and that's the one the DA thought was the final report, and we attached to our founding affidavit. There was a subsequent version of that which uses the correct strict condition language, which apparently is the one that actually served before the National Assembly and is attached to the Minister's answering affidavit. So I apologize for that error. I picked it up when Ms. Pillay was arguing. I think that shows the chaotic nature of the process, that you have so many reports flying back and forth, it's difficult to keep track of them. My client didn't know about this later report when we filed this application. But I don't think this significantly affects the case. I'd like to emphasize a point that both Justice Savage and Justice LaFranci made, that Action SAs, the way you read their proposal reads very differently if they're against the VAT increase. And that's never recorded in the report. So when you read the subject to a strict condition in paragraph 6.32 of the final report, knowing that Action SA is absolutely against the VAT increase, it reads very differently, but that's never recorded in the report. My learned friend also made something of the fact that there was a change from, that Action SA changed it from an amendment to the fiscal framework to a condition, a strict condition, and that this means that, well, it wasn't an amendment. We accept it wasn't an amendment. She's correct. We accept it's not an amendment. The problem is it's also not a clear acceptance, and that's why it's unlawful. And it doesn't matter from our perspective whether it's binding on the minister or not binding on the minister. It at least contemplates the possibility that the fiscal framework will be amended by Parliament. And that is enough to render it inconsistent with Section 8.4. And I urge my learned friend to correctly concede that if the minister comes back with alternative proposals, it will require Parliament to amend the fiscal framework in order to give effect to those proposals. So how can the fiscal framework serve its purpose of guiding the legislation that's before Parliament, serving as the guardrails within which they must appropriate and raise revenue, if, as Parliament itself accepts, it might change? The last point on the question of whether we have to challenge the committees. I understood my learned friend to concede that the committee's reports had no legal effect. If they had no legal effect, then Odecral doesn't apply to them. They don't have to be set aside because they have no legal effect. There's nothing to set aside. And that's exactly why they are part of a multi-stage decision-making process. It's a report to whom? A report to the National Assembly about what its sub-organ, the committee, recommends it should do. And it is only when the National Assembly or the National Council of Provinces adopts the report, which must have a clear statement accepting the fiscal framework, that Parliament adopts the fiscal framework. And that has the legal effect of triggering the next step in the budget process.
Can Parliament amend it, the report?
Yes, it can. Parliament can always amend reports of its committees. And Parliament could also have sent it back to the committee. Parliament, it can do that all the time. Committees are part of Parliament, they're not some separate entity. So its choice was not accept or reject, because what happens if it rejects the committee's report? What then? Rejection means we're going to send it back to you. So it could either change it itself and adopt its own version, or it could send it back to the committee and say, we don't think this has a clear statement. Please amend it, come back with a clear statement that we can vote on.
Okay. All right, your time is up, Mr. Bishop. Yes, is there anything that is really pressing?
No, those are my submissions.
Okay, thank you so much. Mr. Ngcukaitobi.
Thank you, Madam. I have 5 topics, but I will be very, very brief on all of them. The first is just to explain the minister's deception, which hasn't actually been answered. despite the attempts. So the problem with the minister is that he, in paragraph 81, and that's the paragraph they rely upon, sorry, 80.1, which is at 0345. So he first refers to what the EFF says at paragraph 99 to 100. Because he says the EFF says that my decision was unconstitutional because I acted with deception and dishonesty. The basis for this appears to be an accusation that I gave the public the impression that the VAT rate increase could still change, even though I allegedly knew it would not. The submission is unsupported. And then he says, with respect, this allegation is both unsupported by any evidence and difficult to follow. This is what he then says. I have never suggested that I could revoke the announcement at will, nor have I misled the public. From the outset of my announcement, the National Treasury, SARS, and I have consistently and publicly stated that the VAT rate will increase to 15.5% on 1 March 2025. That remains my position. So that's the first element of the deception. He says in his affidavit, I've never told you that this would be subject to a change. From the beginning up until now, I always told you it would be increased. The problem with that is that it cannot be squared up with paragraph 47.1, 47.2, 47.3, 47.4, which is what the EFF says he told Arthur Trollope, particularly at paragraph 47.3, where Arthur Trollope says, in a text message with the minister, the latter says to him, I imagine he will be able to come up with proposals to replace the revenue proposals. So rather than dispensing with the allegation of deception, paragraph 80.1 and 80.2 and 80.3 simply prove the deception. So the minister, I'm afraid, has been deceptive. And this is part of the duty of the court, is to call out the deceptions. The second point goes to the irregularities in the process. The irregularities are much more severe than I originally made. The final version that was put before Parliament, the DA said it was Annexa 13, but it turns out not to be Annexa 13, it's Annexa 7.42. But the last paragraph of that shows the problem, because the last paragraph of what is contained in the Parliament's report is not reflected as an Action SA proposal. It's reflected as a committee proposal. So the committee adopted it word for word. And the last part of it says, furthermore, the committee recommends that the alternative revenue proposals and expenditure savings to balance the 28 billion shortfall. Then it says, which must effectively suspend the proposed increase, be finalized and submitted by the committee to process within 30 days for consideration and adoption of this report by the House. So they themselves say these revenue proposals must effectively suspend the proposed increase.
Which page are you on in the report?
That's a good question. 05366 and 05367. So the paragraph of that report, that's the final report that went to Parliament, is 6.33. So they themselves said these revenue proposals must effectively suspend the proposed increases. So that too was deceptive, because it lied to the public by creating the impression that this VAT rate increase is subject to change. Now we have a speaker who says that it is never subject to change. We had a minister who said it was never subject to change. And they simply cannot answer the problem. So both the minister and Parliament have in fact misled the public. Then there is the problem. I know Madam Justice presiding, you debated with me whether this is deception or shows confusion. And I suggested to your ladyship, if it's not deceptive, it shows confusion. Either way, I come home because it's fundamentally irrational. Then the third point is around substantive equality. I actually agree with Ms. Pillay that it would not be possible for the court in these proceedings to do the equality balancing exercise that I am arguing. But the point is not that you should do the exercise yourselves. The point is that it is common cause that Parliament did not engage with the substantive equality problems that its own report identified. And it did not identify it in one paragraph, it identified it in 6 paragraphs. So she's wrong there in saying it was 1 paragraph, it's 6 paragraphs. And they never responded to any of them. There was one response which was 0 rating, but they themselves explained why 0 rating was not possible. So what you can say, which is not complex, which is not novel, is that where Parliament is faced with a substantive constitutional problem, it has a duty of engaging with it at the very least to avoid substantive irrationality. Then the last point is remedy. The only thing I want to suggest insofar as remedy is concerned is, firstly, I don't have the problem of not challenging Parliament's decision. I've challenged both of them. I would like both of them to be suspended. But if the interdict that I said in paragraph 5 is to be considered, it has to be clear that it includes the VAT rate increase. The last thing we want is for the public not to know what the consequences of a judgment by this court are. Thank you.
What should the argument, Mr. Ngcukaitobi, that the committee decision had no legal effect?
Well, I don't think it is a correct argument because Section 8 creates the committee as a separate body that makes its own decision that have legal effect, independently of the parliamentary process. And it gives it unique powers. It's not a subcommittee of Parliament, it's a statutorily formulated body.
What is the legal effect?
Well, the legal effect is that when it goes to Parliament with its report, and the report is unlawful, and Parliament acts on the basis of an unlawful report, it would, if it influences Parliament to act, then you could set aside the decision of Parliament on the basis that the basis on which they acted was an illegally adopted a subcommittee report. But does it have legal effects to the public as a whole? I would submit it does, because those committees, what they do, this is the engine of the budgeting process, because this is where they evaluate the submissions we make. They recorded 48 of the submissions, and they evaluated each and every one of them. They are the ones who told us that out of that 48, only 2 supported the VAT increase. It was PwC and PEP. Everyone else objected to the VAT increase. They also have the power, by the way, over the minister. And that's absolutely important, because if you look at Section 8.6, it explains when the report has been amended, what happens. When the report has been amended, it comes back, because the minister is given 2 days to make amendments and then come back to Parliament. So they have power even over the minister when they have made an amendment. And that actually becomes crucial, justices, because if the effect of what HNSA did was an amendment, then it was wrong for it to serve in Parliament, because it should have gone back to the committee for recalibration and redeliberation. But the reason it went through is because they actually never had any genuine intention of engaging with this. Thank you.
So you're saying because of the effective amendment, it should have gone to the minister first.
Yes.
And the minister responds, and then that response is debated and discussed, and then goes back to the committee before it goes to...
That's the 2-day response.
That's the 2-day response. But the reason it didn't go is what Justice Savage was saying, which is this was a scheme. They never really had any intention of debating any of these things. What they did, they got HNSA naively to go with them. And once they procured that vote, then they decided, let's run this thing through. Now, there is a fundamental problem with this. Public power should not be procured by deceptive means. If a parliamentarian had been bribed in order to secure their vote, that invalidates the vote. That applies equally to a vote that's procured through deception. So the section says 8.6. If the report includes amendments to the fiscal framework or revenue proposals, amendments to the revenue proposals must comply with section 11.3 of this Act. The minister must be given at least 2 days to respond to the report and any proposed amendments prior to the submission of the respective reports to the House. And C, the respective reports of the Committee on Finance must include the responses of the minister. So you now have a 3-stage. Minister responds, goes back to the committee, and then it goes back to Parliament.
Okay. I just want to ask this last question from my side. You said that you agree with Ms. Pillay that it's not the court that has to engage with the test of whether or not that increase should have been done or not, should have been effected or not. But what you're asking is that the court should look at the duty that Parliament had to engage with this issue. Is that the case that's been pleaded by the EFF?
Yes, in fact we argued it, not just pleaded it.
Okay.
But it's certainly the case, both pleaded and certainly in the founding and in the reply, we complained a lot about sort of Parliament's poo-pooing of the equality programs that is created. But in the reply we attached a full paper by a learned person from the EFF who's an economist. And we argued it fully in the papers, but it's split.
All right, we're just going to ask for a few minutes. We're just going to adjourn for just 2 minutes, and we'll come back just now. Got adjourns. The manner in which you have assisted the court with your
process is